for 19 and 20 on behalf of the Standing Council of Indian Oil Corporation. 19, 20. I've taken the consent of the petitioners last evening.
Okay. You are
On behalf of Standing Council, IOC.
Okay. So, no. Okay, Mr.
IOC Standing Council is Mr. Navneet Borua. Navneet Borua.
Appearing on behalf of the Standing Council, our IOC, with the consent of the Learned Council for the petitioner, prays for adjournment of the matter for.
My lord, he has prayed for May. Can it be posted on 14th May?
Okay. Making mention on behalf of the Standing Council IOC with the consent of the Learned Council for the petitioner.
Yes,
Prays for listing this matter on
14th May.
14 May.
May.
Fine,
14 May.
interim order that may be continued.
Okay. 14 May.
14 May.
Okay. The prayer is allowed.
My lord, I have no knowledge about item number 20, whether there is a interim order or not. So any interim may be continued.
Yes.
The interim order was earlier will continue till the next date of posting. In item 20.
Item 20.
20 just
In my case, there is a list.
here also Standing Council.
Yes.
Standing Council for
IOC. Indian Oil
item
Corporation.
20 also.
20 also, my lord. 19 and 20.
May it please your lordship.
Yes.
My lord, I've just appeared on via VC. I am the Standing Counsel for IOC. My junior colleague has mentioned. I agree with it. There is no interim order in 20, only in 19.
There's none. Okay. Okay. This is on 14th.
14th May 2025.
Similar order. So only the interim portion leave it here until 20. Okay.
Highly obliged.
I'm obliged.
May Your Lordship. Your Lordship, I'd like to mention WPC 167/2024. This is a compensation matter and there is no stay. So the compensation can be dispersed anytime. So may be listed on 2nd of April.
Item
It is not listed today.
not listed.
Yes,
Second of
2nd of April.
okay.
Much obliged.
Yeah, please, Lordship. Item 22. I am correspondent number 4. I have received additional affidavit filed by petitioner today itself.
Additional affidavit filed by
Petitioner
okay.
22.
So
Adjourn for at least 3 weeks.
okay. Mr. R.B. Yadav, Learned Council appearing on behalf of
Respondent number 4.
respondent number 4. So who have you informed the petitioner?
Yes, yes.
Okay. Somebody said he has received the additional affidavit filed by the petitioner and needs to which he needs some time to go through the same and prays for adjournment of the matter for the day. He has also obtained consent from the Learned Council for the petitioner. Please pray for list this matter after
3 weeks.
3 weeks. Okay.
Obliged.
Lordship, recent petition is filed challenging the interim order dated 11/3/2025 passed by the Learned Court Law, Sessions Court, UP. The interim order is placed at page number 18.
This is trivial revision.
Yeah. Basically, Lordship, I am challenging the last part, Mary, Lordship, the operative
Yes.
portion. third paragraph. I have page number 19. I have carefully perused the charge sheet, statement of witnesses, SL report, and other relevant documents available in the case record, and found that there is a prima facie material under section 57, 307, 506 of IPC read with section 27, subclause 1 of Arms Act, which requires framing of charge against the accused person and for trial. Accordingly, the charge under section so and so, read with section 27, subclause 1 of Arms Act is framed against the accused person. Lordship, this portion I am not challenging, I am not disputing. Lordship. Now, Lordship, the charges thereafter next, Lordship. Issue summons to the witnesses, namely so and so for their examination as PWS. And Lordship, on examination of the case record, it is found that one arm license bearing number so and so to one so and other arm license bearing number so and so duplicate. It issued in the name of one Sri so and so by the district magistrate, public additional district commissioner Lower Sibonsri, whereas it is observed that the said license holder are from Karadadi, who resides at Itanagar, and they are not residents of Lower Sibonsri. Besides, it is observed that said license were issued in spite of issuance of blanket ban by the Home Ministry in issuance of arm license in the state of Arunachal Pradesh. It is prima facie observed that above arm license were issued without following Arms Act and rules and the notification of the state government, and the arms so acquired is used for commission of present offense. It is also observed that Sri so and so, who is license holder, has failed to keep the arm and handed over the same to accused person without having license, who has committed present offense. In view of above, Lordship, I am challenging this question. In view of above, the Department of Home, Government of Arunachal Pradesh, is directed to conduct an inquiry regarding said arm license and initiate action against for cancellation of the same and any other necessary action under law. Send a copy of this order to the Commissioner, Home, Government of Arunachal Pradesh, Itanagar, for information and necessary action.
This amount to lodging of complaint against the illegal issuance of arm license.
Yes, Lordship. Lordship, while priming the passer.
Yes.
Yes, Lordship, it's a very interesting thing, Your Lordship. We have to, in fact, appreciate the 228 because this order is nothing but a framing of charge order. Prima facie case is there, basing on the charge has been framed. But later on, Your Lordship, in my humble understanding,
This amount
exceeded the jurisdiction.
This amount to complaint.
Yes, Your Lordship. And Your Lordship, in fact, Your Lordship, the material whichever placed before the court by the prosecution, basing on that, if court found that there is a ground to presume that the offense has been committed and not the ground for convicting the accused. So even that second part also comes because Your Lordship will find that during that period, the license has been issued to this person. That means the learned trial court has accepted without going into the trial, whether this aspect has been done or not. They've given a finding. And second part, Your Lordship, directing the authority, whether under 228 this kind of order can be passed or not. According to my understanding, no, Your Lordship.
So that is why this amount to complaint.
Yes, Your Lordship.
So
Actually, Your
which can
Lordship,
be only after, of course.
the learned trial court has a power for direction of registration of for further investigation before framing of the charges. If all this aspect has been found, then in that case, he can give a direction to the police to further investigate it. But after framing of charge, he has exceeded his jurisdiction under 228. So, Your Lordship, from here, Your Lordship, the learned trial court has exceeded. I will point it out. Your Lordship will find in page 19, Your Lordship.
Yes.
Last, on examination on record, on examination of case record. Till, Your Lordship, issue of witness, namely so and so, this is absolutely fine. But after that, on examination of the case record, from here he has exceeded his jurisdiction. Till, Your Lordship, the necessary action. The last paragraph, till, Your Lordship, till Itanagar, Your Lordship. List the case for appearance of the accused for examination and for the report regarding by the Home Department, Your Lordship. Now here is a case there is a license. It is admitted fact because from the order is clearly reflected that there is a license which has been issued to suppose A, and A has without authority given that gun against which the license has been issued to B, and B has illegally used it. For that charge has been framed. But now later on, your lordship, the learned trial court has stated that on that particular year there was a blanket ban, basing on which notification, if we assuming that this is correct.
You mean to say that the license
Yes, your lordship.
is the fake?
No, no,
What
your
you
lordship.
meant to say? Because there was a blanket ban.
Yes, your lordship. But your lordship, from
How it was issued?
yeah, that is the
So
issue, your
if
lordship.
he has produced any license before the court, that is a fact.
Yes, your lordship. License is
Or
there,
fraudulently obtained.
and that is the part
That
of
is why it
yes.
amounts to complaint.
that is the part of the case diary, your lordship.
Mm.
The license is there. Now the concerned trial court has is saying that at that point of time there was a blanket ban.
Mm.
Now whether there is any material on the record which says at that point of time there was a blanket ban.
That is why I'm saying.
Yes.
This amount to complaint.
Yes, your lordship. And this cannot be done, your lordship, by the. So this part, your lordship, is required to be expunged, your lordship, interfered. The other part is absolutely fine. So far as the framing of charge under section 457, 307, 506, read with 27(1) of the Arms Act.
Okay, hard, Mr. Ingo, Direct counsel for the petitioner. I've also heard Mr. Okay, Direct additional PP for the state of Arunachal Pradesh. The petitioner, this is an application filed under section is 438.
Yes, your revision, criminal revision petition, 438,
So 442.
read with 520. 520 is the inherent power, your lordship.
Your challenge is no to the entire impugn order.
I am not challenging the charge framed against the accused person.
Only that part, your lordship.
Okay. Okay. By filing this application under section 438, 442, read with section 5 to 8 of the BNS, the petitioner has challenged the impugn order dated 11/3/2025
This part may be quoted, your lordship.
in respect of the direction of the
In page 19, your lordship.
trial court to inquire regarding the arm license. And regarding the issuance of arm license and to initiate action for cancellation of the same. Stop. The relevant portion of the order is quoted below. Page 19.
Last paragraph.
Last paragraph on examination to
Yes.
till last. Okay. The Adana Council for the petition submits that while framing charge at the time of hearing the question of charge, the learned court, trial court, while framing charge against the accused for offense under section 457, so 307, so 506 of IPC, read with section 27, within bracket 1 of Arms Act has exceeded this jurisdiction by directing the Department of Home, Government of Arunachal Pradesh, to conduct an inquiry regarding the arm license granted to one who is the owner of the arms,
Dari
Gora,
Raju.
huh?
Dari Raju.
Dare
Raju.
Raju, and to initiate action for cancellation of then
No, so Dari Raju and Gora Tubum. 2%.
it was issued to 2 persons.
Yes.
No, license must have been
Yes. Dare Raju.
1 person or Dare Raju.
Dare Raju, Dare Raju.
And to take action, take necessary action under the law and to report before the trial court, state court on 4/6/2025. The appropriate court. Setting aside the setting aside any punch, the said observation from the order dated 11/3/2025. Starting. Para. Mr. Theatre, non-additional PP. Purely submit that the order dated 11/3/2025 is correct so far as the framing of charge against the accused for offense. Offense under section 457, 307, 507 of IPC, read with section 27(1) of Arms Act. However, after reading over and explaining the accused of the charge framed against him from the learned trial judge has exceeded the jurisdiction under 228 of CRPC.
Your slash, your lordship, 251 of BNSS, your lordship.
251 of DNS by making observation regarding the issuance of license by the department to one, what was the name? Gora, Dari Raju.
Sorry, Raju.
Stating that at the relevant point of time, there was a blanket ban. Where do we find that ban portion?
Ban portion in page 20, your lordship.
Banned by the Home Ministry in issuance of home license in the state of Arunachal Pradesh. And while observing that the license holder failed to keep the arms and handed over the same to the accused, had directed the Department of Home Government of Arunachal Pradesh to conduct inquiry regarding the said the issuance of the said arm license and initiate action for cancellation of the same. And also to take necessary action under the law. Not only that, the trial court has also directed the Home Department to report regarding action taken on report the report again on 4/6/2025 regarding the action taken on the above direction staff. This according to the Land Council for the and thus according to the land addition people could not have issued while passing order while hearing and passing order on under section 227 of
228, your lordship, slash 251 of BNSS. 228 is the CRPC, your lordship.
Okay. 228 CRPC slash
251. 51
51.
of BNSS.
So this order goes,
This part only.
this part.
Later, your lordship, the date for appearance of the accused of the examination of PWs will remain intact.
Okay. Part of the Land Council for the parties. Upon hearing and on consideration, primary facility appears that while hearing on the question of charge under section 228 slash that one CRPC and BNS, 251 BNS from while framing charge against the accused for the offense under sections same, so from the land trial court has exceeded his jurisdiction under the same provisions of law by directing the Home Department to conduct inquiry regarding the arm license issued to Dari Raju, and also to initiate action for cancellation of the sale and to take necessary action under the law. In view of the above, the part of the order that is the portion of the order that is that order quoted below, quote the same, is hereby set aside and passed. The rest of the order shall remain as it is.
Yes, Your Lordship.
Shall remain as it is. With the above, this
Your Lordship, and it may be clarified that the date for appearance of the accused.
and including the date of appearance of the accused on 4/6/2024.
No, that will stand, Your Lordship. On that day, it is for examination of the prosecution.
That is right.
Yes.
Including.
Yes.
But that to remain as it is.
Yes, yes, Your Lordship.
Including the date of appearance of the accused on 4/6/2025.
Yes.
With the above, this criminal revision petition stands allowed in this point.
Yes, yes. Partially allowed, Your Lordship.
To the extent as indicated above and this point.
Yes, Your Lordship. Deeply obliged.
Fine, yeah. Yeah.
That-
What is this?
that-
Just charge sheet.
That is a charge sheet, Your Lordship. It's not required to be considered.
Oh.
Obliged, Your Lordship.
Lordship. Lordship, this is a revision petition.
Okay.
Lordship, the fact of the case is that the petitioner herein have purchased the land from the respondent in the year 1998.
Hmm.
But the respondent have disputed the purchase and sale of the land after 13 years. On 2013 only, the respondent started the complaint about the sale and purchasing of the land by the petitioner. Thereafter, Lordship, what happened? The respondent, they have approached the civil court, London Civil Court, Along, by filing the title suit, which Lordship will find at page number 16, Lordship, the judgment of 17, Lordship.
It is title suit.
This,
By?
this is the judgment order of that title suit. Title suit number 16
Page
of
17,
yes, 16 Lordship.
page 16.
16 onward.
No.
17 onward. Lordship.
16 is. 17 is.
17. This is the
This is-
outcome of the title suit filed by the respondent.
This is not a petition.
Lordship,
Okay, judgment.
yes. Now, Lordship, while pronouncing the judgment, the London Civil Court has ordered in favor of the present respondent. Lordship. And after that,
Present respondent.
yes, present respondent. Now, after that,
Wait. Let us see the conclusion. Operative portion. Okay, who filed this title suit? You said,
the present respondent.
oh, respondent filed
Yes,
title
sir.
suit, and then it was passed.
Yes. In favor of the respondent.
In favor of the respondent.
Respondent, Lordship. Against this judgment, impugn judgment,
Hmm.
the present petitioner,
Hmm.
they have filed a statutory appeal before the London District Court
Okay.
under section 15 of 15 surplus 2 of APCC Act 21.
Okay.
And now appeal is pending before the District Court.
Hmm.
And Lordship, while admitting the appeal of the present petitioner, the London District Court has pleased to grant interim by suspending this impugn judgment passed by the London Civil Court. Lordship.
Mhm.
And during the course of hearing, that the present respondent, they have filed again one execution petition before learned civil judge. And after hearing,
Was there any stay in the appeal?
Lordship, yes, appeal is already admitted and it is in the
Do-
final hearing is due.
Okay, while there was a stay in the appeal,
Yes, there was a stay, Lordship.
then he filed
But-
execution petition.
Yes,
No, execution petition was filed while,
filed by the present respondent during the pendency of appeal.
okay,
And now, Lordship, while admitting the appeal, the learned district court has granted the interim, suspending the impugned judgment order passed by the learned civil court. And during the course of hearing, it was interim, ad interim, Lordship. And during the course of hearing, the learned district court has vacated the interim order passed earlier, Lordship.
okay,
And in the meantime, the respondent, they have pressed for listing of the execution petition filed earlier before the passing of this interim order, Lordship. Now, the execution petition have listed yesterday itself, Lordship, before the learned civil judge.
yesterday,
Yes, Lordship.
what is the result?
Lordship, I have annexed the code list, page number 74, Lordship.
Yesterday's close list,
Yes, Lordship. Last item number 25, Lordship.
27.
Page number 76, item number 25.
Okay.
Now, yesterday,
Item
the
number, page 74.
page 76, Lordship, 76.
76.
Yes, last item number, last 25, Lordship.
Oh, no, page 74. It's a continuation, item 25.
Yes, Lordship.
25
This-
is,
This is the
item 25.
item 25 is the
Hello.
execution petition that has took up yesterday, Lordship, on 27 by the learned civil court.
Oh, yes, what happened there?
Now, Lordship, the largest civil judge, they have issued a notice to the deputy commissioner COME, but that order I have failed to access since yesterday the hearing was conducted. I am
Notice for
instruct-
what? Notice for what? To the C.
notice for initiating
Okay.
the execution of the impugned judgment. Now, Lordship, the petitioner herein have residing at the disputed area land for last 30 years, Lordship. And now they have constructing the RCC building over the disputed land.
When this judgment was passed by the trial court, it was way back in the year 2023.
24, Lordship. 24, 16 January 2024.
No,
Lordship.
judgment is 18/12/2023. Civil judge.
Yes, Lordship.
Okay, and then the vacation order, when?
Lordship.
When the interim was vacated?
Interim order granted on 12.
No, when it was vacated?
It was vacated on, Lordship.
24, 25,
Yes, Lordship.
recently. Okay,
Now, Lordship, since my appeal is pending before the learned district judge, Lordship, if during the pendency of appeal, if the execution is carried out, then the petitioner would be highly prejudiced, Lordship. This is the only residential building where petitioners are presently residing, Lordship. There is no any other means to reside.
so if the,
At
if
least-
the lane is not yours, then
Lordship, for that, I have already filed an appeal petition before the learned district judge.
say after,
Appellate court also.
even after granting interim also,
Yes, Lordship.
the said appellate court has vacated again,
Yes, Lordship, that is the Lordship.
vacated.
But Lordship, my prayer is very limited, Lordship. Till the outcome of this appeal petition pending before the London Appellate Court, this execution petition may kindly be suspended, Lordship. And I am ready to cooperate with the outcome of the appeal, which is pending before London Appellate Court. This is my limited prayer, Lordship.
Okay, hard Mr. Haringo, land counsel for the petition. So, is this the appeal? So revision petition, revision.
Yes, revision. Civil legal.
In the revision, you need to, whether you need to file separate step petition or in the same.
Lordship, this is read with order 21, rule 29 of CPC Lordship. Stay of execution, Lordship.
Then where is the revision then?
Lordship, along with this petition.
But in the civil revision, where, this is civil revision.
Yes, Lordship, read with section 20, order 21 of rule 29.
But in the civil revision, you have to satisfy certain things. What is the,
Yes, Lordship, I am basically, my prayer is very limited, Lordship. I am not
maybe,
seeking
maybe.
for
but
revision
the-
of the order, interim
But
order.
if it is civil revision, you have to satisfy that there is, the exceeded the jurisdiction.
Lordship, the petitioner here is not seeking for the revision of the interim order, Lordship. Just staying of the execution petition, Lordship.
Now, unless you challenge the impugn order in revision, then only for stay, how do we grant?
Lordship, for that,
Unless you challenge the order itself.
Lordship, for that, my appeal petition is already pending before the learned appellate court, Lordship. So during the pendency of that appeal,
Okay,
the respondent, they have filed an execution petition. For that only, I'm before this honorable court, Lordship.
but this is against that order passed in the revision. So this is also revision. You have filed this revision.
No, Lordship, that is appeal, Lordship.
Which one?
Statutory appeal, Lordship.
But this is revision.
We have, during the pendency of appeal, Lordship, the respondent, they have again filed the execution petition, Lordship.
Yes.
So I am.
But this is revision of the revision to that execution petition.
Yes, Lordship.
That is what I'm saying. What is wrong in the order?
Yes, Lordship, order, yesterday only the order is passed, Lordship. And I have failed to
Where
access
is
that,
that order?
I have failed to access that order since I have filed this petition, Lordship, yesterday. I was mentioning yesterday only.
Any order passed yesterday?
Yes, Lordship, they have directing the deputy commissioner. For that, Lordship, I will file the additional affidavit in next date of hearing, Lordship. But till then, this execution petition.
But what I'm saying is this is ultimately, this is civil revision against the order, impugn order passed in the appeal. Is that a final order?
No, that is not final order, Lordship. I am not challenging the entire order, Lordship. I am not challenging the impugn
No,
order.
but then you, in the revision, since this is a revision, you have to satisfy the court that he has exceeded the jurisdiction or not exercised the jurisdiction.
Lordship, I am before this honorable court only for the actions of the respondent.
That is why I'm saying. You are challenging the order.
No,
Isn't it?
no, Lordship, I am not challenging the order. I am challenging the execution petition, Lordship.
Execution petition. In the execution petition, they have passed an order.
Yes, Lordship.
Let us see your prayer.
Right.
Hmm.
In the premises above, Lordship, I said your petitioner most respectfully find that your Lordship may be pleased to call records and issue the rule calling upon the respondent to so called as to why the impugn execution petition was. Number so and so pending before London Civil Jail, Western District, in status suit number 2116 shall not be set aside. I'm not challenging also the entire order. I'm challenging only the execution petition number 04 of 2024. The prayer is too limited, Lordship. Till the outcome of the title appeal, and which is about to arrive into final litigation. Now the final argument is only remaining.
Under what circumstances the revision can be filed? Can we just see the provision? Since we have filed this revision.
Lordship, Order 21, Rule 29, which is about the stay of execution.
This is an application. Just by filing this application under Article 227 of the Constitution of India, read with Order 21, Rule 29 of CPC, the petitioner is seeking a stay of the execution of judgment stroke decree and setting aside and passing of execution petition number 04/2024 filed in title suit number 21/2016 pending before the Court of Civil Judge within bracket Senior Division bracket close West Siam District Hall. Issue notice. Record is necessary. Call for the scan copy of the record. The petitioner shall take steps upon the respondent by a registered post which aiding as well as by a usual process within a week from today. Place this matter after 4 weeks.
Lordship, record pertaining to the execution petition number 04 of 2020.
Record, this is execution petition only. Records. Execution is before the civil judge.
Civil judge.
The appeal is otherwise before the
Not district judge.
session,
Yes.
sorry, district judge only.
Yes.
So when we call for the record, it's The civil judge, the record of civil judge only. Okay, record pertaining to the execution petition number 04/2024. In title suit number 21/2016. The land counsel for the petition submits that the case, the said, the execution petition, where is the last order? Have you annexed?
Lordship,
Where is the last order fixing for 27?
execution petition, Lordship.
In the execution petition, where is the last order whereby whereby the trial court has fixed the next date for 27?
Yeah.
Have you annexed the last order?
Lordship, that was not, they have, the respondent, they have put up. Mentioned for put up of the execution petition. After that, the ST has put up the matter on and listed on 27.
Okay, the land counsel for the petition has submitted that the above execution petition number 04/2024 was listed yesterday on 27/3/2025, and he does not have a copy of the order passed in the last order passed in the state execution petition. He that had come till the you are residing there.
Yes, Lordship, I'm residing in the disputed land for last 30 years. Single noti village, Lordship. Basically, this is not a notified village.
Okay, having regards to the contention made in the petition, it is provided that the okay, do that as in absence of the last order passed by the trial court. This court is not in a position to pass any interim order. However, considering the contention made in the petition, it is provided that a status quo over the land in question. In the execution petition, there must be a prayer for the eviction of
Yes,
the,
eviction.
okay.
No coercive action may not be. No coercive action may not be taken against.
It is provided that no coercive action shall be initiated pursuant to the. Is there any order?
No, Lordship, order they, yesterday they have filed. Order I will file the additional affidavit in next date of hearing. Before next date of hearing. And Lordship,
Who will say no coercive, will say just status quo.
yes,
Okay.
no, any consequential order shall not be effective, Lordship, till the returnable.
Status quo over the. This is the lane already decided in favor of the respondent only
Yes, Lordship.
over the lane.
Appeal is
Shall be maintained till the next returnable date. Okay.
Deeply
This is my, I've said this is after 4 weeks, huh?
Maybe please, your lordship.
Yeah.
Your lordship, this is a joint petition for quashing of FIR dated FIR dated 03/05/2023 in connection with Itanagar PS case number 86/2023.
The case is now, whether the case has been submitted into charge sheet?
Yes, your lordship.
Okay.
Accused has been, petitioner has been already charged sheeted before the CGM, learned CGM UPR.
Okay, this is accident case.
Yes, your lordship.
You are for which one?
Uh,
For the informant or for the respondent?
your honor, I'm for all the petitioner
Okay,
because this has been amicably settled
so it appears, yes,
on the basis of,
the complaint was lodged by the informant, but then charge sheet was filed by the, filed against the informant itself.
yes, your lordship, because
Yes.
during the
Because
course,
he probably. So, but since it's an accident case and they have amicably settled, where is the settlement copy?
your lordship, annex number
So what do
3.
you have to say? Mr. Tarafi?
There's a technical defect in this petition that the affidavit was shown in one commonly by this judge.
Oh, no, all have to. All the petitioner.
Have to shown in
Now
separate
we do not know,
separately.
because here you see, record speaks. Record speaks for itself, that the complainant, he lodged FIR against against two person. And then the police has submitted charge sheet against him,
Yes.
instead of submitting charge sheet against the accused, alleged accused. So now we can't believe this. So you have to file affidavit. All. No. Yes, page 12,
Page 12,
yes,
this is an affidavit and 13.
no, just see, name of all the applicant.
Yes,
Here it is. All have declared.
yes, general practice before here in this high court is that if even if there is a yes, petition, they have to file separate
No, see, all the petitioner says that we, the petitioner. Can you see page 12?
yes,
This is not correct one.
yes, we the undersigned.
Is this not the correct one?
Yes, what I submit before this court is that this affidavit should be in separate set by separate petition.
Now, in one affidavit, all of them have given their name, address, age, etc., and then declared jointly.
Yes, yes, your lordship. Since this is a joint petition,
And all of them have signed.
yes, your lordship.
This probably was accepted by the registry. What is the normal practice?
Normal practice here is to file a
But
separate
this was
affidavit.
accepted only, see, 4 of them have
Yes,
declared.
I accept your lordship. I accept that there is no straight jacket formula rule for this.
Then I think they have. See, this was accepted by the registry. Should have pointed out otherwise registry, if it was not correct one. So all of them have jointly, we the petitioners.
Yes, we the understand.
declared.
Yes,
See,
it is there.
so anything else other than this?
No, other than that. They have
What is the
executed.
stage of the trial?
Actually, your lordship, this case is charged sheeted before the CGM, but trial is not yet proceed. It is about to commence trial.
Okay. Pursuant to the charge sheet submitted, the CGM has not stated any steps,
Yes, your lordship.
not started any
It
steps.
is given evidence stage.
Kept in abeyance. Whether it was, have you mentioned GR case? Whether
Yes.
case,
Your case number
where?
293 oblique, it is, your lordship,
Hmm?
I have annexed, some portion of charge sheet.
No, no, where is the registration of the case before the court of the chief judicial magistrate? After receipt of the charge sheet, they must have registered.
Your lordship, GR case number 293 oblique.
Where do we find it? Where?
Your
Page-
lordship, it is page 16. I have annexed, some portion of, this charge sheet.
No, where have you stated in your petition that to set aside and quash the said GR case? Where?
Your lordship,
I think you need to.
that
correct
has
it.
been not mentioned.
Then which case is to be set aside? Case has not yet started, no number, nothing. You have to correct, I think, the prayer also. And in the post title also, you have to include the GR case number against whom, against which case you have come. Or challenging which case, which GR case. Because you said that case has already been submitted in the charge sheet.
Yes,
This- With you, this police case only is available before the court. You have to, I think, amend your petition. Include the GR case number, which is pending before the chief judicial magistrate, which you want to be set aside to and quashed. You have to include. There is also no prayer. So since it is no longer with the police, FIR cannot be, since it has already submitted into charge sheet, you have to pray for setting aside and passing of the said case. Have you understood?
yes, your lordship.
The young boy,
Hmm.
I was listening quickly.
Ah.
It happens by mistake, right?
Yes, yes, that is why he
Yes,
need
sir.
to
So
include,
kindly give him liberty
Okay.
to withdraw this and file it. please.
that will be better.
With all the,
Mr.
you take affidavit of
Okay.
all the,
Okay,
petition.
Mr.
Pitali.
Land Council for the petition. Some is that there is, okay, he wants to withdraw this criminal petition with liberty to file affairs after making necessary correction. The prayer is allowed. This criminal petition is dismissed on being withdrawn with liberty is prayed for. Okay.
Obliged.
Mr. Tado, Land Council, Land Edison CP is present. Okay. Yes.
Your Lordship, I am seeking for an adjournment in this case, Your Lordship, on behalf of Mr. R.S. Tamam, Your Lordship.
Okay.
He is unwell, Your Lordship, and he has requested this court, Your Lordship, to fix the matter on 2nd of April, Your Lordship. A very short date, Your Lordship.
Better file affidavit. Okay, it's prayed for by Mr. Riva. Take it, when do you want?
Tuesday, Your Lordship, for
Tuesday.
2nd of April.
Because only day I have. In the earlier, probably the notice was already issued, no interim was granted. So we take up the, because only for passing interim order, he was seeking some time to obtain instruction. So we take up it on Tuesday.
In this case, there are two petitions.
Yes,
95 of 95
Yes.
2025.
Yes.
It was also heard on 7 March.
yes,
And on that day also the court has clearly directed to the additional court.
yes, to obtain instruction.
To seek the instruction. Now, again after that, due to the certain changes, when we have challenged as per WPC number 95, we have challenged the recommendation.
Whether you have taken steps upon the respondent number 6, 7, 8, and 9.
Yes, we have taken. We have taken.
Hmm.
So here also, record has been called, and here he was asked to take the instruction, and in spite of that, and even record was also asked to produce to the record. Then in that case, if I am failed to demonstrate, prima facie establish the case, in that case, that is different. But while I am demonstrating for and establish the prima facie of the case, and it's a clear cut inherent violation of the term and condition of the tender. Instead of that, a person has been recommended. That is the illegality. That is the irregularity. So, after establishing the prima facie, interim may be granted.
Your Lordship, this is my humble prayer, Your Lordship. May it be fixed on 2nd of April, Your Lordship. By that time, Mr.
Yeah.
Arachanama will be appearing in this case, Your Lordship.
The interim arrangement made till the 31st of this month, and I am the carrying point of contractor. Then, if it is expired, then they are adopting the best tactic before the court, and court has seen it.
Your Lordship, that is not the case, Your Lordship. This morning itself, I received a call from Mr. Arachanama, Your Lordship. He has some health issues, Your Lordship, which is why yesterday also he didn't attend the court, Your Lordship.
Even interim,
Monday is holiday.
Yes,
So
Your
it's
Lordship.
Tuesday,
Tuesday,
then
Your Lordship.
immediate next day.
Yes, Your Lordship.
So he has some health issue. It's difficult.
no, till Tuesday, also interim can be granted. Interim can be granted. I never said a fixing of date. I will not have my any objection. Let them fix whatever they like. Still returnable.
By an order dated 24/3/2025. The Mr. Navam, the additional Advocate General sought for some time to obtain necessary instruction in the matter. However, today Mr. Riram, Lani Government Advocate, informed this court that due to some health issue, the Mr. Navam, Lani Additional Advocate, could not make the court. Therefore, praise for listing this matter on Tuesday. No, Tuesday next. That Tuesday is on
1 year,
okay,
1 year.
1st April. Next Tuesday, that is on 1st April 2025. Starting. List this matter again on Tuesday. Starting. Till then, parents, till then, the which one is impugn order?
Page 46.
46.
Yes.
Page 46.
So this is renewal certificate. 46 is renewal certificate.
Page
We are
46.
on 95. WPC 95.
Page 46.
47.
6.
No, WPC 95.
No.
To suspend. Here, the above appointment shall remain valid for the financial year of 2025-26 and 26-27 only up to 31st 3/2027.
You
This
said
is the-
page 40, 46.
46.
46.
Yes.
46 is order.
Approval order.
Approval for what?
Approval for
Is this a impugn order?
Yes. The tender evaluation committee board has recommended. Then after that, the government has approved. So for recommendation, WPC number 95 was filed. Then again, this petition has been filed against the approval.
Okay, this approval was done pursuant to the board proceedings, which was done on 10 January. Page 48.
Yes.
Is it so?
Yes.
No, 10 January was that. It was day of opening of the tender. Then when the tender was opened, there was an argument amongst all the participants. Then we stopped the proceeding of the opening. But on 23rd, we come to know that a person has been, this response number 7 has been recommended by the board. Then we filed WPC 195.
MS Papu Hotel Multipurpose is the respondent,
Yes,
in favor of whom it was approved.
Papu Hate Multipurpose Cooperative Society.
Now, as of now, you are continuing it.
Till to the 31st months, I am continuing. As per the interim order, as per the arrangement made by the FCI. That is in page, in annexure 20, page 131.
No, what we'll do is, because the certain condition.
Page 131. Annexure 20.
And then non-fulfillment of certain conditions, we cannot just compare them also. We'll take up on Tuesday. Okay, list, page for list is matter on Tuesday. Okay. Tuesday. Tuesday.
Ma'am, interim maybe
Yes,
consider.
only one day.
On that the interim may be considered.
No, no.
On which date, the interim prayer?
Today also it can be
Yes, Your
considered.
Lordship.
Okay.
The interim may be considered. If interim will not be considered, it will be infraction.
No, that yours tenure over by 31st.
31st. And case is fixed on, then what?
We're in 95. Let us just see 95.
95.
The similar method.
Similar method. Similar method. We have challenged 95 that the petitioner response number 7 was recommended.
In 95, where is the impugn order?
That's quite clear. Page 35. Page 35.
So this is board proceeding.
Yes.
Now, where is the order?
Order. This much only they have
Okay, till
given.
then, huh? Okay, till then. It's on so and so, huh? Till then,
MS Papu Hate MHP LTD is found to be with minimum numbers of shortfall in comparison to the other firm. Hence, the board recommend MS Papu Hate Multipurpose Cooperative Society LTD to the Deputy Commissioner Pake Kesang District for initiative further necessary action.
okay, the respondent shall not initiate to act on the impugn order, on the basis of the board proceeding dated 10th January 2025. Till the next return date. Okay. Till then only.
Compliance, mobilization.
At pertain to the court proceedings. Okay, yes.
Well, I'm extremely sorry. The State Human Rights Commission has exceeded the jurisdiction. Well, whenever
Yes, yes.
the State Human
no,
Rights Commission is only to deal with any violation relating to the Human Rights Commission. And from where does the State Human Rights Commission has assumed the jurisdiction to deal with a criminal case, my lord? That here is a case, my lord, the interpolation of the voter ID card. And it then comes under the category of forgery. The human right, will not kindly see this, kindly come to, this is the complaint at lecture 1, page 72, my lord. By email it was sent, my lord. Email it was sent, my lord. And my lord, I just,
It's a complaint.
there is a complaint by the petitioner. Well, kindly see, there's chief secretary, so and so forth. And it has not been addressed even to the State Human Rights Commission, my lord. The first thing my lord will note. Then my lord will kindly come straight to Annexure 7, my lord.
Yes.
Annexure 7, just for a moment, my lord, page 96, my lord.
So this is the initial complaint.
Yes, my lord. In another, the same complainant, my lord, in another read petition, there is a stay order by the coordinate bench. But just I am showing this, I'll place this judgment.
Okay.
On the same issue.
90?
96, my lord. Now, my lord, kindly see
Yes, 96 is.
96,
summon.
yes, my lord, conditional summon. But this is offense involving the forgery and falsification of documents, which in the old sections 468, 471 will
It has
come.
to be before the police.
Yes, this has to be before the police. And my lord, for kind appreciation, my lord, kindly, do you have this copy of Human Rights Act 1993? Just kindly see, my lord, I'll apprise that. Just kindly see. Well, just I am reading in the meantime. Well, kindly see the definition of 1993 Human Rights Commission is section 2D. Section 2 is the definition section, and the clause, clause D, human rights means the rights relating to life, liberty, equality, and dignity of the individual granted by the Constitution or embodied in the international covenants and enforceable by courts in India. That's the first thing. It does not talk about the criminal thing.
Yes, sir.
And
That's-
secondly, then kindly come straight to the section.
Doesn't have power under.
Doesn't
this
have,
part.
correct, And in earlier case, in the item number 1, I was also here.
Okay.
In the item number 1, I had gone through the records. There, while framing the charge, the learned district and session court has exceeded the jurisdiction in 228 CRPC. And then directing to the, it appears above the.
Right.
So similarly, this thing has happened here, my lord. So, my lord, kindly come to section 21. Yes, I assist my lord for a moment. In the chapter 5, the constitution of the state, in fact, this Human Rights Commission was constituted because of one PIL by me only. I'm happy to see the constitution and also trying to correct the jurisdictional error. Well, this is anyway, just I'll. Well, section 21 of the Human Rights Commission Act, chapter 5, it deals with the State Human Rights Commission. The constitution of State Human Rights Commission. So that is one, the principal section. Then in the subsection 5, a state commission may inquire into violation of human rights only in respect of matters relatable to any of the entries enumerated in list 2 and list 3 in the 7th schedule to the Constitution of
Yes.
India. So when we read this 7th schedule means we have to appreciate the objective of Article 246. So it entails the power. None, Manoj. Well, kindly stay this. That in view of this order that I have, only Manoj here the petition, the respondent number is. Huh? Okay. That in this case, the respondent number is 7.
Similar case.
Similar case. And
Similar case means it is not listed today.
No, it's not listed.
Okay,
The
so
new course again.
Similar case, but then
No, party
different
name is
person, different person.
a different person. So then, in this case, Manoj, the complainant is respondent number 7. Here she is respondent number 12.
Okay.
Yeah, in this case.
Hmm. Okay, Mr. Titikara, Land Council for the petition. By filing this petition, the petitioner has challenged the impugned proceedings.
Correct. Procedure.
The
My lord will kindly come to prayer.
proceedings
portion.
initiated by the Human Rights Commission,
Yeah,
by the State Human Rights Commission against the petitioner.
my lord kindly come to page 65. for
Page?
The first prayer, page 65, the prayer portion.
Yes. Proceeding of the case.
Yes, Lord. Case number AR
Okay, initiated by the Human Rights Commission against the petitioner. The filing is seeking challenge the proceeding of the case number AR stroke SHRC stroke case number 13 stroke 05 stroke 2024 pending against the petitioner before the Arunachal Pradesh State Human Rights Commission. Any other?
then including this one, my lord, that the impugned order dated 22/5/2024 and 29/11/2024. This much, my lord.
What order was passed by this?
There, they have
And the order dated 22/5/2024 and 29/11/2024 passed
we make it on April 24.
in the same case.
In the
Passed
same-
in the it passed in the state case. By this order, what he was directed? What was the direction by this order?
The direction was for registration of the FIR against us. So that will, he cannot, if he has not
No, case is already registered now.
registered. My lord, that part kindly skip this. This proceedings may be stopped, that's all.
Okay,
The
that-
Germany of
that
the
will
whole
come
case
because
is
if
from-
it is already registered,
Yes.
it will be trouble. Okay. There is a limited prayer for the time being.
Time being, yes.
Okay. So then issue notice. Returnable by, issue notice. Anyone appearing on behalf of the government is also party. Yes, it appears because there, prima facie,
Yes.
the Human Rights Commission doesn't have a power under part 1 of the schedule itself.
Right.
That is true. But then, of course, can have the power to power under, of course, part 2 and 3, not under part 1. So prima facie, it appears that we exceeded some, but of course, since the case has already been registered, that otherwise also, of course, if it is filed before the IOOC, it can be registered. That part will just
No, but
The-
I'm
that
very
part which
fearing
you
that.
not,
Because then once
yeah,
the proceeding goes on, my lord,
right.
once the proceeding of the
For a time being, the proceeding,
is stayed,
before the
then
human
the
rights.
consequential order also follows, my lord.
Okay.
They
Also-
cannot act
also
anything
are-
against us.
And law. and is
I
uniform.
may not be appearing for this in commission. So I'll be appearing for the government. only.
Except
Okay.
for respondent
yes, yes.
number 12,
You are for
189,
118.
18,
except for 12. Private
9,
respondent,
10.
19.
11 or 12.
No, this is 11 is by name.
No, this is not the group level officer.
By name. it's
Election
name.
officer, no, that's
Issue
Okay,
notice, huh?
correct, correct.
Okay, since Mr.
We
And law,
serve extra.
national
We
government
serve the extra.
advocate
We-
accepted not, appeared and accepted notice on behalf of this respondent. Okay, no formal notice need be issued to the said, need be sent to the said respondent. However, the petitioner said would serve requisite extra copy to the Nane Council
By Tuesday, not coming
Mm.
Tuesday. Tomorrow it is.
For the Nane senior government advocate within, by Tuesday.
Tuesday.
By next Tuesday. The petitioner shall take steps upon the rest of the respondents by a registered post with aid as well as by a usual process within a week from today. Okay,
Correct.
stop, huh? Okay.
Well, kindly list this matter on 24, April, along with this.
This is matter on 24.
24
Page
April.
grade 4 come, this is matter on 24,
April.
4, 2025. Stop. Para. Having regards to the projection made by the petitioner. It is provided that the proceedings before the State Human Rights Commission shall remain state till the next returnable date.
Correct. I mean, that earlier repetition has to be tagged along with this.
So this probably earlier petition is fixed on, not on,
8, it is on
it
8.
is on 8.
Now it can be tagged together, no issue.
Okay. Then in the above,
Interim order will continue.
list is matter along with the writ petition. Number 105, 2025 on
24.
24 April. Okay.
Because kindly all remark, the operation of interim order, this will also continue.
Hmm?
There is an.
In that?
Yes, same order, this is. The operation of interim order in.
Automatically, because this will be listed on 8. On 8, you have to say probably, you have to tell the court,
Correct, but then.
then it will automatically, it will
Automatic.
continue.
Grateful.
Yes,
Yes, my lord. If I may, my lord.
yeah,
My lord, this petition challenges the rejection of the petitioner's bid in a tender notified by NIB dated 13/3/2025. The NIB says notice inviting bid is at annexure 5, page number 21.
Hmm.
This tender is regards to construction of a bridge, my lord.
construction of bridge.
Of a bridge, my lord. So in this tender, my lord, this is a e-tender, but although there was a condition that some physical documents need to be submitted
Yeah.
to the concerned respondents, my lord.
Hmm.
So accordingly, on 18th, the petitioner had submitted his documents, my lord. The physical copies of the document that were asked by the department. After submission of these documents, we have the checklist and the documents have been annexed at annexure 6, page number 22, my lord. So this consists of all the documents that were asked by the department to be submitted physically, in addition to the online submission, my lord. So accordingly, after submission of this, my lord, a receipt at page number 24 was given to the petitioner, my lord. This is a receipt of deposit of original EMD. Now, this receipt was given by respondent number 7, my lord. The respondent number 7 was the person authorized by the respondent number 5 to receive all the physical documents in regards to the tender. However, surprisingly, my lord, when the evaluation report was made public, my lord, it is the evaluation, technical evaluation report is page number 50, annexure 7. Herein, out of the 7 firms, 4 were found to be qualified, 1 to 4, and the firm number 5, 6, and 7, we being firm number 7, at serial number 7. If I may just read, my lord, the last para. It says that, my lord, on opening of technical bid by the board members, it was found that out of 7 intended bidders, 2 numbers of bidders, namely so and so, did not submitted physical documents within due date. That is on 19/03/2025. And one of the bidder, namely Vijay Agarwal and Sons, that is the petitioners, my lord, petitioner, did not submitted physical bid documents as referred in clause 2.11.2 to the designated address mentioned on clause 211.4. So this is the only reason that our bid was rejected, my lord, technically. So now
So
hearing.
this according to you that you have submitted this document.
Yes, my lord,
Where?
because we have a checklist and we have a receipt at page number 24. So we were provided this receipt by the respondent number 7.
Where do we find this particular document?
Lordship, we have submitted this along with the checklist. And then this was the receipt that was provided to us, the petitioner, the authorized representative of the petitioner, on 18th, my lord. Page number 24, my lord.
Page
24, 24.
24.
Yes, Lordship.
Which is the, have you mentioned the document?
Yes, Lordship.
Construction.
The document starts at page number 22. This is a checklist we have submitted on that date, 18th. And after submission of the documents, we will provided this receiver at page number 24, my lord.
Submit physical bid document as referred in 2.11.2. Designated address mentioned on clause. Where is this document? Where do we find this document in annexure 6?
From page number 22 till page number 49, these are the total documents we had submitted, my lord. Annexure 6.
They have specifically mentioned that did not submit physical bid document as referred in so and so. To designated.
Now that is our
What are
contention.
these documents?
Now you know that is our contention.
Entire document.
We have submitted the entire document. Now the contention, our contention, if I may, my lord,
Yes.
our contention is by being that, my lord, we have submitted an EMD of 30 lakhs original. A receipt have been provided to us, and now they are saying that we have not submitted documents, so our bid was rejected. Now you know, my lord, that if our documents are uploaded online also, and we have physically submitted an EMD of 30 lakhs, my lord, but according to them, my lord, the department, we have not provided any documents, my lord. Although we do have a receipt here in there. Well, it does not make sense, my lord, that we will submit an EMD of 30 lakhs and then we will not submit any documents accompanied with the EMD, my lord. And when especially we have uploaded all the documents online, my lord. These documents are also not so bulky, my lord. They are hardly 27 pages of them, my lord, along with the EMD, my lord. So it does, my lord, does not make sense that we'll pay an EMD of 30 lakhs and will not file our documents, my lord. And this was a receipt that was given to us by the respondent number 7. He has signed it.
That is correct, but the document has to reach the authority.
Now, that is also our condition, my lord.
So
Now, that is also one of our contention, my lord, that if after we have deposited it to the person concerned who was supposed to receive it, and we have taken a receipt, now, my lord, the respondents cannot come and say that the document did not reach us. That is their duty, that the person that they have designated for receipt of the document, they should put it there for consideration, my lord. If we have submitted it, as we are saying, we had submitted it on the 18th, my lord.
Now this process proceeded to which stage?
My lord,
Standard process?
in my knowledge, my lord, it the financial it should be in the financial stage, as informed.
So your prayer is?
My lord, my prayer is that my technical bid may be reconsidered, my lord. Because I am an eligible participant who has participated duly by following all the requirement as stipulated by the department, my lord.
So 7 bidders.
7 bidders.
Along with the 7, your name should also be included.
From the 7 bidders, my lord, only 4 were qualified.
Okay, okay,
So if I'm allowed, I will be the 5th, my lord.
okay. So, yes.
If lawsuit come to the page 24 lawsuit, this receipt lawsuit.
Yes.
This is the receipt of depositions of original EMD only lawsuit.
Mhm.
Page 24 lawsuit.
Yes,
And if lawsuit see the page 22,
yes.
page 22 is dated 17 March. And here lawsuit, it seems also some documents have been lawsuit submitted.
Page 22, page
So-
22.
What the petition is submitting is the lawsuit
Yes.
by page 22 lawsuit.
Yes.
By page 22 lawsuit,
Hmm.
there is all the original documents have been submitted. That's the case of the petition lawsuit. But if lawsuit see the page 24 lawsuit,
Yes.
page 24 is the only the receipt of depositions for original EMD only lawsuit. Among the lawsuit, all the original documents, only this is the receipt in respect of EMD only lawsuit. There's nothing on the records to show that lawsuit, these documents have been lawsuit, if it has been received by the authority or it has been submitted to the authority lawsuit. So under on this lawsuit, when lawsuit, even the receipt number is there lawsuit 28. On the top lawsuit, page 24, lawsuit will find receipt number 28.
Yes.
And if lawsuit come to the page 22, there is no receipt remarks is here on page 22 lawsuit.
This is only their letter.
Their letter only lawsuit.
Submission of physical
Yes,
document.
And
No receipt.
definitely when the physical documents are not submitted lawsuit, the bid will be rejected lawsuit. This, therefore, I may be allowed to take instruction lawsuit. It may be listed on Monday or Tuesday lawsuit. Monday is holiday lawsuit.
Mr.
Jitalom.
Jitalom. Not counsel for the petition. Issue notice. Not notice, just a minute. Appearing on behalf of the respondent number. Here's respondent number. Respondent number
1 to 6 lawsuit.
1 to 6. Short for some time to obtain necessary instruction in the matter. Is prayed for, list is made on Tuesday. Okay.
My lord, there was a small prayer hour interim that if in the meantime they issue the work order, that will be in the till at least if it is on Tuesday, my lord, then till Tuesday, no further process may be continued in regards to this tender, my lord.
What is this? That is why I'm asking.
Regarding the status also lawsuit, we are not aware lawsuit.
No,
So
that
it may be considered on next day lawsuit.
That is
the
a-
interim
if-
prayer shall be considered.
My lord, a small
next
prayer.
day. Okay.
If the work order has not been issued, then it can be that way. If work order has not been issued, it may not be issued till Tuesday. That only that part. If work order has not been issued, my lord, then it may not be issued till Tuesday. Now that is a very protective prayer that will protect both the parties. They won't be hampered. We will be also protected. Small prayer, my lord.
Lawsuit without there being a prima facie case lawsuit. Installing the public lawsuit.
Just a minute.
installing the development walls, Lordship, that will not in the interest of public laws. Only a matter of 2 days. Lordship.
We hear your interim prayer also on Tuesday.
Tuesday.
Because here it appears, really it appears that there is no receipt.
That is why we made the person as a party, my lord, the person who is given as the receipt.
Okay.
Much obliged.
May it please lordship, my lord.
Yes, yes.
This is the second round of the writ petition, my lord. Earlier, 4 persons, they have challenged the pending of the decision by the deputy commissioner. So now, altogether, 12 persons. My lord, matter of the fact is that, my lord, here, the government of India decided to construct a hydropower generation and at Italy, Italian hydroelectric power corporation. So government of Arunachal Pradesh accordingly accepted the proposal given by the government of India. So my lord, in person to that, my lord, the government of Arunachal Pradesh has issued preliminary notification, my lord. Annexure 1, my lord. Annexure 1. "14 days time was allowed to the land affected people to raise Annexure 1, page 26, my lord, and
Yes.
notification, preliminary notification, my lord.
To the acquisition.
Issued on 9 November 2012, my lord.
Yes.
So accordingly, my lord, the petitioners, they have submitted the claim in objection regarding the their land. So after assessing the entire assessment, my lord, the petitioners' name and serial list appeared in 23 and 24, my lord. 23 and 24, my lord, yeah. Page number 28, my lord.
28.
Page number 28, my lord. 23,
23.
serial number 23.
Dibam Valley district.
Dibam, right. Ichanli area, my lord. Ichanli.
Yes.
Measuring 23.272 hectares. And 24, serial number 24 is the same area, 16.78 hectares, my lord. And all the boundaries have been described. So, what is my lord? When the process was going on, and that time the other parties, that is Atumbo, Toru clan, this different clan, they have submitted an application before the DC for land allotment matter. So we do not know, when we have not been given any notice regarding this area, my lord, as I have mentioned at page serial number 23 and 24, my lord. Here I have implemented the correspondent number 4, who is claiming their land as their ownership. And we have...
He represents that clan.
Yes, my lord. So, my lord, after getting the complaint from the other side, my lord, petitioner, they have filed representation before the deputy commissioner. Annexure, sorry, my lord, Annexure 2 is, my lord, the final publication, my lord.
After receipt of the complaint from respondent number 4, what did the authority do?
My lord, I'm going with that point. Annexure 3, page 39, my lord. This is the application submitted to the deputy commissioner. Objection on intention of issue of LPC against Chai village.
Is submitted by respondent number 4.
This is submitted by the petitioners, petitioner, my lord. Then subsequently, another application was also.
Petitioner has submitted his objection on
Yes.
extension of issuance of.
So thereafter, my lord,
Objecting what? Objecting what?
regarding my lord, land, my lord. They have changed its Chai village to Ichanli village. Ichanli. So thereafter, my lord, annexure 4, again they have filed another application on 5/3/2014, my lord. Appraisement regarding absolute ownership of land located at Chai village under Italian circle of Dibang Valley district. Referring the earlier dated 4th March 2013. So that earlier application also pending before the commissioner, and this one also pending before the deputy commissioner, my lord. So thereupon, my lord, annexure 5, kindly page, turn to page 44, my lord. May read the deputy commissioner and any Dibang district, Arunachal Pradesh. Subject, objection against the illegal claim compensation. Now they have come to the land compensation, my lord. Hectares.
So who, this was submitted by?
Petitioners, my lord. Mitaso Mimi.
Objection against the illegally claimed compensation.
Yes, my lord. By the Atoma Taru clan. Atoma clan, my lord.
So, okay, they have raised objection. The claim of the respondent clan. Atoma Taru clan is the respondent number 4.
4, man. He is representing all the clans. So, my lord, subsequently, another application is also there, my lord, annexure 6, page 45. My lord, type copy is page 46, my lord.
Yes.
So, they have claimed the same, reiterated the same demand that
What is their demand?
They are the real ownership of the land, my lord.
Okay.
So, it should be adjudicated
So,
first.
whether after receipt of the complaint from the respondent number 4 clan, whether deputy commissioner has done anything against
As on today, no any action has been taken, my lord. This is
but
the.
if only the complaint, the respondent number 4 has lodged complaint against you.
Yes, my lord.
But the DC has not acted upon it.
No.
Done nothing.
Nothing, my lord. As on today, my lord.
Okay, then you are agreed by what?
We are agreed by because of the non-action on the part of the respondent number 2.
Okay.
That is deputy commissioner.
Okay,
So now,
despite your submission of representation and reminder.
my lord.
Okay.
So, my lord,
what is your prayer now?
my prayer is that, my lord, as per the Arunachal Pradesh Civil Court Act, my lord, 2021, my lord, section 2, subsection D, customary court has been empowered for adjudication of any value, my lord. There is no limit of the value, my lord. So, secondly, my lord, thereafter, my lord, amendment
You want that this matter between you and respondent number 4 be
My
settled by the
local
village
authority. Yes, my lord.
Now, for that, you at least have to lodge complaint before the local authority.
My lord,
DC doesn't have a power, doesn't have any power to endorse it.
yeah.
You independently, you can lodge complaint against respondent number 4 before the Gamura.
My lord, difficulty is that our petitions are pending before DC.
Okay,
So, this may be.
DC from his side
Yeah,
has to dispose of this.
yes, it may be disposed of.
Is it okay that if we direct the deputy commissioner to dispose of the matter by giving some time?
Or, my lord, or it may be given to the transfer to the, my lord, the village authority, my lord.
Because then the other side will again lodge complaint because DC doesn't have a power to endorse to the Gamburas. Under this, you have independently, you can submit complaint before the GBs, but then DC doesn't have a power under AFR to endorse it again.
Then, my lord, Lada Deputy Commissioner should endorse to the Circle officer, Italy.
Okay.
All
Yes.
the pending cases are there.
Yes. So probably he has a limited prayer now, that the commissioner against the inaction of the deputy commissioner not disposing. of the
Yes,
deputy
my lord,
commissioner.
but first of all, whether this is the land dispute is in connection with what has been acquired. I don't will kindly say what was the notification and page 26. What my learned senior has said. This preliminary notification was for around 27 places, my lord, areas.
Yes.
At serial number 23 and 24, which the petitioners claim that it is their place, my lord.
Yes.
This is Ichanli, the areas factors on. Then this was in the year, my lord, 2012, 9 November 2012. The final notification also has been, the type copy is at page 35, you know. This was, I think, 18/7/2013, final notification. This has also been done. Turning circle. And serial number 2324, Ichanili. This is the same. Already final notification has been done. Now, their complaint at page 29 or 39, the annexure 3. They say page 39.
Yes.
They are descendant of Chai village who they are talking about Chai village.
Chai and
Against
Italian
Chai
is
village.
same.
I will
Same
say
Page 39.
39.
Where Chai village? Where do we find?
That's serial number 1 of the paragraph, paragraph 1.
We are the descendant of later.
And then
Chai.
Chaiye village.
Hmm.
Then 4. Further, we kindly request your company not to issue land possession certificate against Chaiye village under area to anyone who does not belong to Rambutaru clan. This is not even an objection to the preliminary notification, but an objection for intention of issuance of LPC against Chai village. That notification is of Ichanali, this is of Chai. Then at serial number 4, also annexure 4, page 41. Here also, Malo, they talk about Chaiye village. Page 41. With,
Then located Chai village.
yes.
Yes.
So Chaiye village, and then they say that these are to be proposed to be acquired for hydropower project company. They have given written it to the DC and not to pay compensation for Chaiye village. Whereas the compensation, the notification, there is
By this representation, what did you say?
it says that this representation, it talks about their land located at Chaiye village.
Mhm.
They,
And their prayer is
not to, my lord will see that under, sir, we are to submit that since the above land belongs to us, we have been doing farming and on the said land, and if the land is acquired by any company, in that event, we shall be bound to suffer both mentally as well as economically, as our fertile land shall be taken up by the company, and proper compensation must be awarded to the prevailing land acquisition act under the government of, under the above mentioned facts and circumstances. We are requested to kindly look into the matter with the so and so.
further LPC should not be in favor of. Now, Chaye village is not even in the notification. Maybe that for that matter, my lord, these have never been acted upon. Then my lord will kindly come. In the event, they at page 50, my lord, annexure 8A. Earlier, my lord will recall that the land acquisition proceedings started page 50, my lord.
Page 20.
50, 50. 50. My lord, land acquisition proceedings was initiated under the earlier Land Acquisition Act 1894. My lord, in 2012, it was notified, preliminary notification. Then in 2013, final notification was done. In the meantime, the LARA Act came into force, my lord. Now, here the Secretary Land Management has said,
What act came into force?
LARA, the new right to fair compensation,
Mhm.
Act came into force in 2013, my lord.
Mhm.
Then it was notified in 2014 by the state government. But by the time already final notification was done in the earlier this act, my lord. Here, my lord, in 2018, the secretary has said that with reference to so and so, I am to convey government approval for award section 11 of Land Acquisition Act for the land measuring so and so proposed to be acquired for so and so Dibang Valley in Dibang Valley as per subsection 1 of section 24 of right to fair compensation in the land acquisition so and so. Meaning thereby there is already an award. Award will be, there is already an award which will be as per the right to fair compensation. Now, that is done in the year 2018. Now, thereafter, whether the compensation has already been paid or not, if there is an award, then the petitioners, if they object that these persons are not entitled to get the compensation, they should have approached the competent authority, that is the this
Deputy Commissioner.
not the deputy commissioner,
Yes.
the reference this by
Whatever maybe, since they have already they have submitted representation and demanded before the deputy commissioner. So deputy commissioner stating the fact that this is not connected with land or whatever maybe,
May-
can dispose of the representation.
Yeah.
that it should not be connected with this
Whether it is connected or not. the
only
deputy commissioner-
only
deputy
the
commissioner will tell
representation,
them-
yes, final. Otherwise, if on the strength of if there is any interim given saying that till the disposal nothing should then that might be means hamper the developmental process, that only. Otherwise, if there is a dispute between the private respondent and that can be settled in any other forum. Only the developmental, what we are concerned is the development work should not be hampered, my lord. The acquisition process, if it has been completed, then completed. If not completed, then it should not be stopped.
My lord,
That-
from the petitioner,
Because of the dispute, ownership dispute between two individuals, two private individuals, the development
from
work.
the petitioner side, my lord, they have no any objection against the, my lord, the authority, my lord, regarding acquisition of the land.
So
Because
only your prayer is not to issue land possession certificate or any to the opposite party.
that is a
The
part,
respondent number 4.
that is a part.
Okay, so then
And mainly, my lord,
There is
ownership,
a
my lord.
private
Because the
respondent.
private restaurant
regarding
four,
ownership,
private restaurant four, he has a land at page street number 17 and 18, my lord. Private restaurant four, my lord. And his village, name of the village is Alo, my lord. A-A-L-O, Alo.
which is the prayer in your representation which you want to highlight? Prayer before the deputy commissioner. What is your basic prayer before the deputy commissioner?
My lord, annexure four, my lord, page 41. They have narrated very exhaustively, my lord. I think, my lord, if it is, my lord, incumbent on the part of the Tribunal Court to settle the case, my lord, as per the customary way, my lord. Because it will take hardly 2 days. Whether instead of 2 days, deputy commissioner taken since 2013 to till today.
If it is a dispute of a land dispute or the dispute of the fact, it can be settled by the court. Deputy commissioner probably have no power now.
No, I mean to say, my lord, local customary court, my lord.
Customary again, see, if the deputy commissioner entertaining your complaint, this complaint, if the deputy commissioner endorse it to anyone for settlement, again, the other side will again challenge deputy commissioner.
And
doesn't have
my
any
lord,
power
in that event, my lord,
unless both the party agree.
my lord, in that event, my lord, I am maybe allowed to file a press application before the, my lord, on competent forum, my lord.
Okay, so at least the deputy commissioner can say that because this week I cannot settle for this, you have to go to the civil court or the appropriate forum.
Because we are in between, my lord, and we are in a dilemma, my lord.
Mhm.
So,
So
if
DC can only at least guide at the appropriate forum,
yes,
maybe Gambara or maybe civil court.
Yes.
But the disposing of that, the deputy commissioner doesn't have a power. to
Yes,
settle.
right.
At least saying
Yes,
that also
right.
we can dispose of the representation.
that is the, my lord, only way. And in the meanwhile, my lord, small prayer,
Hmm.
in that event,
Hmm.
my lord, today or tomorrow, suppose land compensation are paid,
Hmm.
my lord, it will have a great prejudice on the part of the petitioner, my lord, because they are the landowner.
No, yes, deputy commissioner. So
And so,
according to you, you are entitled for the compensation.
yes, my lord.
But the other side, the respondent.
They are claiming,
who
they are
claiming.
yes. There
So
is a
then-
claim and
then
counterclaim, my lord.
Naturally, probably, if the case are pending, if there is a dispute between the party, deputy commissioner probably, unless he decide, unless that the ownership of the lane is decided, he
Yes,
will
ma'am.
not be able to release.
And it should
He is
have
the
been-
person who is to release.
Yeah. It should have been decided long time back, but
Mhm.
still pending, my lord.
Okay.
No payment has been made because of our all complaints. So it may be disposed of with the direction that they should go to the appropriate forum to settle the issue. This will suffice the my lord entire matter.
That is the fear. Indirectly stopping this acquisition process.
And my lord, it will not
Because
affect the
the
developmental
very area-
activities, my lord.
That is not in the notification. Final or preliminary or final, my lord. The very earlier claim by the petitioner. Now, if
Okay,
they,
then what we can do is, since there is a private respondent also.
yes, there is a private respondent, we don't know the actual fact.
Notice issue, and in the meantime, there is no
Let-
bar.
let-
no bar.
Notice be issued, my lord. Let notice be issued, my lord, as
No bar,
suggested by
no
the
bar
learned
on
advocate
the
general.
part of the deputy commissioner to dispose of the
Yes,
representation
yes, that
subject by
no
the
bar.
petitioner. Will it be okay? We'll say that no bar on the part of the deputy commissioner to dispose of the representation submitted by the petitioner in the meantime.
Yes.
Okay. Mr. Peace on Planning Council for petition.
In the meanwhile, no any such, my lord, disbursement of the land compensation. Till such period, my lord.
Whether the disbursement started?
Not yet.
Not yet.
It is going to be, my lord.
Okay. I've also heard Mr. Leland, land additional advocation for the state of Arunachal Pradesh. So, fair. So that means basically you are not challenging any notification, any order.
No, my lord.
Okay.
My lord, my prayer are limited, my lord. 1, 2, 3, page 22, my lord. of my petition, my lord.
This matter, this prayer probably is also not connected with the respondent event. If we direct the deputy commissioner to dispose of the representation submitted by the petitioner,
Yes, my lord.
because
That can be, if, but the effect will be the respondent also, my lord.
no, because
My lord make direct
we-
that representation that what
no,
representation.
for disposing of the representation submitted by the petitioner, probably the respondent will also be not affected. How? he will
Yes,
be-
my lord, in that event, my lord will let the DC dispose of
Yes,
the representation that if my
three representation.
20
Three,
representation
Uh,
in respect of the land Chaye village, that may be reflected.
But in all the case, in all the representation, we have mentioned only Chaye village.
Chaye village.
Chaye village.
Yes. So Chaye village is not there even in the.
Chanli,
Whatever may be the representation, because
Yes. So there is no question of installing the disbursement process of the compensation.
my lord, Chanli and this Chai village is same. Because same is same.
have you
Only
mentioned
because of the
anywhere
LPC,
in your
my lord,
No,
because of the
nowhere in the
LPC.
three representations.
LPG have been obtained on the basis of the
anywhere in
respondent
your
for.
representation, have you stated that
No,
the Italy
it's-
and the Chai is the
it is
same?
not-
But we have mentioned this is our land. We are the ancestor of the land. And
Nowhere they
descendant
have
of the
mentioned
land.
that these are the same land.
No, kindly spare. And minor one thing that as per the National Civil Code, minor the DC cannot also take up such matter because after 1 year of lapse of 1 year, DC cannot entertain such matter. There's a time period is there. So it will be minor most appropriate to issue a direction that let the matter be settled by the local authority.
Settled by the
Local authorities. This is the latest rule of the land.
My lord, that direction. In fact,
that direction, it may not be possible.
yes, my
because
lord.
it-
The
Deputy Commissioner can give option that either option while disposing of. So this Deputy Commissioner doesn't have a power to settle. So for that settlement of the land dispute, you either approach the civil court or
That
to
will, yes, that
or
will
to-
come.
the Gamraj.
Yes.
Yes, my lord. Therefore, my lord, in fact,
But that direction,
liberties should be given to the petitioners to
Yes.
approach the appropriate court.
Commissioner will
Now,
give.
no need to, even to the deputy commissioner, they can approach the appropriate court.
Directly.
Yes,
that
directly.
can also be.
Why burden with this and just for the sake of stalling the
So
disbursement?
this writ, in the writ petition, it will be limited that directing the deputy commissioner to dispose of the representation submitted by you.
Yes.
Okay, okay. So your claim is you are actually the owner of the
Yes, ma'am.
ancestor.
Ancestral land.
By filing this writ petition, the writ petition. You are not challenging also. No, then. Okay,
Madam, I have mentioned in the synopsis also, madam.
Hmm?
In the synopsis. Also.
Okay. So here they have mentioned Ichanli
Slash
stroke slash
Chai.
Chai village. By filing this application under Article 226 of the Constitution of India, the petitioner is seeking direction to the Deputy Commissioner. Deputy Commissioner, which Deputy Commissioner?
Anini, man.
Anini.
Dibang Valley district, Anini.
To dispose of the representation submitted, by the petitioners on which date?
4th March 2013.
2013.
Then next 5th March 2014.
2014 and
16 December 2014.
2014.
And also, my lord, memorandum also submitted on 11 March 2024. This is the latest.
Okay, then prior earlier we comma and then last and 16.
11 March 2014.
11 March 2014. Okay, stop. Para. The case of the petitioner is that.
My lord, sorry, 11 March 2024, my lord.
2020.
Latest.
Yes, the case of the petitioner is that they are the owner of Ichanli from Chai village and the Italian circle of Dibang Valley, district Arunachal Pradesh. And therefore they are the land affected families of Ichanli stroke Chai village localities of MS Italian hydroelectric power project of 3097 MW megawatt. Stop. It is submitted that the proposed hydroelectric power project will submerge the paddy fields of the petitioners. Stop. When the preliminary notification for acquisition of land was issued, the petitioners raised objection of the purported claim made by the Atoma Taru is respondent number 4.
Why not?
Claim made by the respondent number 4. Atoma Taru clan, respondent number 4, stating that their claim was unnecessary. Stop. Accordingly, the preliminary notification dated 9/11/2012 was published by the authority, and the petitioner's name appeared in serial number, and the serial number 2324 is not the petitioner's name. Petitioner's name. It's not the petitioner's name. It's the
Not the name.
Other names
petitioner's name.
not the
It's
name. It's
alias
a
name.
clan name.
Clan name.
Okay. The petitioner's clan name appeared in serial
No,
number.
my lord, it's not even the clan name, it's the area name.
Okay, it's area name. Actually, it's area only, I think.
Yes.
Okay, the petitioner's clan's area's name appear in serial number 23 and 24. As they are the Rambu Daru clan and descendants of the Rambu Daru clan. Stop. However, due to false claim made by the respondent number 4, the petitioner's land compensation have been put on hold. Stop. aggrieved by the claim made by the respondent number 4. The petitioners have submitted a representation before the respondent number 2. Submitted the representation before the respondent number 2. What was the prayer in the representation? First representation?
For issuance
To
of
sign the MPC and.
Okay. Respondent number 2, praying for issuance of LPC. In your favor?
Yes.
Okay, in favor of in their favor. However, the said, and thereafter subsequently, the petitioner has submitted reminder application, reminder representation. That first representation was on 4th March 2013. Yes, that is the one. Next 3.
Yes.
Yes,
Both
yes.
ones.
A reminder representation on 25/3/2014.
In December 2014, lecture 5.
16.
Yes, on top.
16/12/2014, and finally on 4/6. No,
11/3/2024.
11/3/2004.
24.
However, all the above representations submitted before the respondent number 2 is still pending disposal. The learned counsel for the petitioner submitted. Now the respondent number 2 is going to disperse the land compensation within a short period without deciding or disposing of the representation submitted by the petitioner. Petitioners, which is likely to cause which may cause these unless it is decided that we cause the dispute between the petitioner and the respondent.
Yes.
With regards to the payment of the compensation. So however, at this stage, the limited prayer of the petitioner is that to direct that this writ petition can be disposed of with the direction to the respondent number 2, the deputy commissioner, respondent number 2, to dispose of the above representations submitted by the petitioner and decide the ownership of the land.
No, that cannot be, my lord.
No. His prayer.
Oh, yes.
His prayer. Ownership of the land. Stop. Para. Mr. Nino Ratan. Lanet additional advertisement. On the other hand, some is that so far as the disposal of the representation submitted by the petitioner by the respondent number 2, he has no objection. However, the prayer of the petitioner that the matter be decided by the deputy the ownership of the land be decided by the deputy commissioner may not be possible, inasmuch as the deputy commissioner has no power and authority to decide the title and ownership of the land in question. So therefore, he has therefore he submits that the this is prayed for by the land council for the petitioner. This writ petition may be disposed of with the direction to the deputy commissioner to dispose of the representation submitted by the various representations submitted by the writ petitioner and giving liberty
Without deciding the ownership.
without deciding the ownership. Who further may also give liberty to the petitioner to approach the appropriate forum, including the civil court as well and the local
Or the.
Local authority,
Customary.
customary court for deciding the ownership of the land. So that part of the land council for the parties and also produce the record stuff. Upon consideration of the submission made by both the land council for the parties and agreed upon by the land council for the parties, this writ petition is disposed of with the direction to the deputy commissioner to dispose of the representations dated so and so, okay, submitted by the petitioner.
Within a period, Myra.
Within
a period.
Okay. Okay.
Without deciding the ownership.
No, within a period of.
Within a short period, preferably within a period, preferably within
2 weeks.
60,
2 weeks.
within 30 days from the date of receipt of this order.
Without deciding the ownership.
He will
Not
not
already mentioned.
automatically.
Otherwise, again.
He will not decide.
No, because my submission and then my lord's direction may also, without deciding the ownership. It has been only,
We have clarified that he doesn't have a power to decide the title.
that may be clarified in your direction, madam.
The petitioner is also given liberty to file. You want to file the fresh the representation also?
And liberty will include everything, Myra. You want to approach before the appropriate forum.
Liberty to file fresh representation and also to
That can be
approach.
added, that can be added.
The petitioner is at liberty to file fresh representation before the respondent number 2 and also to approach the appropriate forum for settlement of the land dispute between the respondent number 4 staff. Yeah.
Well, interim, no interim maybe, otherwise this will.
This petition stands.
That is already
before
mentioned.
disposal of. Okay, because without settling, he will not be not
Yes.
Yes.
able to dispose.
Yes, no, it will not disperse.
Okay, disposal.
Much obliged, man. I may be allowed to correct some date is mentioned, wrongly mentioned.
Where?
In the registry, I'm corrected by with pen.
Which one?
In the writ petition, man.
In the writ petition?
Yes.
Disposed.
Disposed of.
Disposed.
No problem.
We are not.
Obliged.
Obliged.
Lordship, this is case challenging the order for the recovery of my payment, Lordship, excess payment, whereas there is nothing all like that, Lordship.
Recovery of?
Lordship, excess payment, Lordship.
Okay.
Lordship, phase number.
Full issue notice? Issue notice? Okay. Or Mr.?
G. Kato, Lordship.
Okay, G. Kato, land council for that. Recovery started, not yet.
No, Lordship, it is not started.
Not started.
So within that, it has given some certain time to recover within the time, Lordship. Within the 24 months that it should be recovered, Lordship.
Okay.
And Lordship, there is clear case, Lordship, if without admitting the fact also, if there is a payment for the 5 years, over the 5 years.
What do you mean? Off करना है?
Lordship, and over the 5 years, if there is a payment, there cannot be recovery.
There is also,
Supplicant by time.
there is also interim, prayer.
Lordship, yes, and prayer.
Where is the impugn order?
Impugn order is, Lordship, page number 21, Lordship.
Page
21.
21.
Page 20. Yes, Lordship.
21 is the impugn
20,
order.
yes, Lordship, 2021, Lordship.
20.
And it is reflected in 21 that the finance and account officer.
So where? 21 is a copy only. The
Yes,
finance and account officer.
Lordship, there is.
So, there are for information, please. He is requested to recover.
Yes, Lordship.
As per the directive of the accountant and so on.
And Lordship, there is one beautiful judgment that if even payment is made within 5 years, there cannot be recovered as per the record.
Recovery is difficult because you did not demand. They have paid by that. Recovery is little difficult something. Okay. Heard Mr. Jikato, Lane Counsel for the petitioner. I've also heard Mr. Nane Law, Lane Senior Government Advocate for this state respondent number 1, 2, 3 is also. 3 is Director of Audit and Pension.
Yes.
Okay. For others, 1, 2, 3, start. By filing this application under Article 226 of the Constitution of India, the petitioner has challenged the impugn order dated 25/11/2024, by which the authority is sought to recover. Recover what? This is excess payment.
Lordship, actually, this is for increment.
Increment.
Yes, increment is entitlement of the every employer when it is promoted and duration of the membership. Lordship, and moreover, there is no reason has been given and assigned.
Where is the order for recovery?
Lordship, this is Lordship, 2021, may I read, Lordship? As per this order.
As per the Directorate of
Executive.
Have been rectified and refixed.
And next page, direction has been given, Lordship.
Whereby the finance and account officer, water resource department, within bracket, Western Zone, WZ, bracket for Vichanagar, has been directed to recover excess drawal of pay or excess drawal of pay by the petitioner and to deposit the same to the treasury within 24 months. So, okay. Fair issue notice stops returnable by 4 weeks. This is Mr. Enloan, and as senior government advocate, appeared and accepted notice on behalf of all the respondents. No formal notice required to be issued. However, the petitioner shall furnish requisite extra copies to the senior government advocate within 4 days, within 5 days from today. You furnish extra copy because audit and pension would require another executive. Okay. list this matter after 4 weeks. So having considering the contention made and upon hearing the counsel, hearing the learned counsel prosecution, it is hereby provided that the operation of the impugn order dated 25/11/2024, whereby the finance and account officer, Water Resource Department, Western Zone, Canada, has been directed to recover excess trial of pay of the officer and deposit the same to the treasury within 24 months shall remain suspended till the next returnable date. Okay. Obligation.
May I please, Lordship?
Yes.
Lordship, I have challenged the impugn order dated 31/10/2023, passed by the Executive Magistrate Court, Kanku Division, Lower Siang District. Page number 40, Annexure 9. Lordship, this is a execution order passed by the executive magistrate in connection with a land dispute case between the petitioner and the respondent. Lordship, this is with regards to, Lordship, a village land in between Sechep and Pere under Richirite and Sililipik village under Kanku circle. Lordship, the case of the petitioner is that since 1977, the petitioner and his clan member, they are Dagnyo clan members, they were residing in this particular plot of land. Thereafter, Lordship, in the year 1994, a land dispute cropped up, and in that land dispute also, the said particular land has been decided in favor of the petitioner. Thereafter, Lordship, again on 15/8/2018, a Keba
94, it was decided in your favor.
Yes,
By
Lordship.
whom?
And Lordship, by the customary court, and Lordship, thereafter the land is in our possession, and till now also the land is in our possession, and we are,
Can we just see where is the decision of 1994?
Lordship, that has not been annexed here, but the position is, adverse position of the land is in our favor, Lordship.
Okay.
There again, Lordship, on 15/8/2000,
On what basis you
possession,
submitted in the year 1994, it was decided in your favor?
yes.
On what basis?
Lordship, possession, because Lordship,
Possession.
yes. And Lordship, thereafter land dispute cropped up in the year 2018.
2018?
Yes, Lordship. So in the year 2018, that is on 15/8/2018, Lordship, a Keba was held.
15/5.
Lordship,
15/5, 2018.
2018, 15/5/2018.
Yes.
A Keba was conducted under the chairmanship of one Donya Taipodia, who is the head Gambura of Lipu village under Likavli circle, Lower Siang district. Lordship, in this particular Keba settlement agreement or the Keba order, the ownership of the land has been given to the respondent, private respondent number 6, Lordship. Being agreed.
In the said Keba.
Yes, Lordship. In the Keba of 15/5/2000.
Who those complaint in that Keba, for that Keba?
Keba was, we are the respondent in the Keba.
Okay, so the respondent filed complaint against you. because it was under your possession.
Yes, Lordship.
So the Kebang decided in
Against
favor of
us,
respondent
against,
number 6.
yes, yes, in favor of respondent number 6 and against the petitioner.
Yes.
Thereafter, Lordship, being agreed with that Keba decision and within the limitation period as provided under Arunachal Assam Frontier Regulation of Justice Administration 1945, we have filed an appeal before the Deputy Commissioner.
Okay.
So our appeal is pending, Lordship. Lordship, our appeal is pending. Page number 26 of
You filed appeal before Deputy Commissioner.
Lordship.
Page.
Lordship. Page 26, Lordship. This is the appeal.
26.
Yes, Lordship. To the Deputy Commissioner, reference Banco level Keba decision so and so. Appeal against the above mentioned Keba concluded under the chairmanship of Donya Taipodia, head Gambura.
So this appeal is still pending.
Yes, Lordship. Lordship, now.
Now, whether this appeal has been transferred.
No, no, Lordship.
Not yet transmitted to the.
Yes, yes. As per the amendment of Arunachal Pradesh Civil Court Act, the appeal has to be transferred before the civil court. But without doing that, Lordship, again, by this impugn order, the respondent number 6, private respondent number 6, and they have passed an order by this impugn order. Now they have, the executing court has directed DLRSO to issue LPC with regards to this present disputed suit of land despite of pendency of my appeal. Lordship, being agreed with this execution petition, I came before this honorable court.
Yeah. We'll continue at 2. So notice can, what is your submission? Notice can be issued?
Yes, Your Lord, at this stage, yes.
Okay. So then in the meantime, what about his execution petition?
Your Lordship,
Because he has filed, the appeal is still filed, but
Yes,
the
yes.
appeal, no order was passed.
No order was passed. It is still
But
pending.
No order was passed, no interim, nothing, then in that case.
Yes, Lordship.
Difficult.
Your Lordship,
Appeal is,
Execution, we can't stop
in response to the
unless there is a stay.
RTI
Yes, Lord.
application filed by the petitioner, the Office of the Deputy Commissioner has furnished that the appeal filed by Dangyo clan against the Bango level Keba dated 15/5/2018, no, not available in the
So
records
that
of the.
means, appeal was not filed, what they are saying.
Yes,
Trying to
yes.
say.
And Your Lordship, if we look into Annexure 2, page number 20, Your Lordship, and Annexure 5, page number 26, they are the same copy, but in Annexure 2, seal of the Office of the Deputy Commissioner is there, but in Annexure 5, there is no seal of the Office of the Deputy Commissioner, Your Lordship.
Will issue notice?
Lordship, in
Yes,
the
sir.
meantime,
In the
interim.
meantime, because it will be difficult. Because they say that your appeal is not available,
Lordship,
whether received.
yes, Lordship, we have filed a RTI to this effect, and as per our RTI application, they have furnished the copy of appeal.
Appeal against.
Yes, Lordship, page number 20 is the page number 20 annexure 2. This is the copy of appeal which I have filed before the Deputy
Page
Commissioner.
20,
Yes, Lordship, which bears the seal and signature.
2018, but
Yeah.
then what is page 26?
Page 26 is
Same
the
copy, Your
copy
Lordship, but
which they have given through RTI.
Okay,
Yes, Lordship.
then
Yes, I have obtained the copy of,
I think this is the same.
yes, Lordship, same.
Okay, we'll pass over after 2. We'll continue at 2.
Your Lordship, I have a matter at the principal seat, Your Lordship. Go
I
ahead,
have no
bench.
problem.
Yes,
Okay.
yes. Yes. Obliged.
Your presence will be recorded.
Yes, yes.
Okay.
May I continue, Lordship?
Yes.
Yes. Lordships, since I have filed the appeal before the Deputy Commissioner on dated 28/5/2018, and it is not yet been heard and disposed by the authority. And now the respondent number 6 has filed this execution petition, and
Let us see execution petition, what it says. Any order passed pursuant to the execution petition? In
Yes.
the execution petition?
yes.
What is the order?
Lordship, now they have filed an execution petition, and now they have directed the DLRSO of the concerned district to issue LPC in favor of the private respondent number 6
Okay.
with regards to that disputed land. But my appeal is pending before the Deputy Commissioner.
So let us see the impugned order, the operating motion.
Page number 44, last page. First para. Hence, there is no.
44?
Yes, Lordship, page number 44.
Yes.
Hence, the office of the DLRSO legally shall consider the application of decree holder for issue of LPC in regards to decretal land, if any. However, regarding construction of hut at decretal land, no photograph is attached to substantiate the claim. Hence, this court is not inclined to give any relief as
This was decided
by the executive magistrate,
no. The earlier case was decided by,
the village authority.
well, let us see that order.
Page number 18, Lordship. This is the type copy.
Yes, it's a Bango Kebang.
Yes, Lordship. Bango Keba decision dated 15/5/2018. A land dispute Keba meeting was held under the chairperson of Sri Donya Taipodia, head Gambura of Liru, with regards to land dispute of Tangku Circle. The land dispute between Dagnyo and Barsi community was decided under the chairmanship of Bidam Gibo, head GB. The land dispute of Barsi, that is Sili Lipu area agreement dated 16 March 2018, where the decision is passed by order dated so and so, dated 27 January 2018. The Keba decision was rejected by Dagnyo community, and the said disputed land matter was referred to Likavli Bango Keba. Today, case circle is fixed for the following points. The complaint of Dagnyo community is regarding the ancestral land. The Barsi community are claiming that from 1986 to 1994, the Dagnyo community has an incident for which they abandoned the land, but they cannot reclaim the land now, though the land is owned by Pedi Buchi. However, the land was transferred to Barsi 23 years ago, and the Thai clan also held Keba for the last 9 years, and Dagnyo also took written permission from Barsi regarding things in Sililipi area, but also Sri Dagnyo Taipodia GB said that we are not claiming the land, and also stated that hydro project dam has been initiated. After the discussion and also going through all the documents, decision was passed. It is also apparent that the said disputed land belonged to Buchi clan, and on friendly relationship Dagnyo community were allowed to stay in the land temporarily.
Okay, you are Dagnio clan.
Yes, Your Honor. And
So you were, according to this decision, you were just allowed to stay.
yes, this decision is against me.
Hmm.
I being agreed with this decision has filed an appeal.
So this was decided on 18.
Yes,
You filed appeal on
28/5.
28
Yes,
May,
within limitation period.
which was received by the district land review.
Yes.
Yes. Hmm. Will issue notice? Yes.
Notice and also
Okay, Mr. T. Taba, Land Council for the petition. I also had Mr. In-law, Land Senior Government Advocate for the state, for the respondent number 1, 2, 3.
1, 2, 3,
4,
4,
5.
5,
Okay.
5.
Hmm. Issue notice, since Mr. Lower Land Senior Government Advocate has accepted notice on behalf of the respondent number 1 to 5. Government notice may be sent to the said respondents. However, the petitioner shall furnish extra copy, repeated copies to the Land Senior Council within 4 days from today. The petitioner shall take steps upon the respondent number 6 by a register post with AD, as well as by usual process within a week from today. So, list this matter. Whether record need to be called?
yes, Lord.
Okay. Then you should not, after you should not, it's called for the record of, is there any case number?
Lordship.
Is there any case number? Because,
Yes, Lordship.
and then you say that this record is not available, where from they will produce now that?
Lordship.
This record is not available before the ADC.
Lordship, record will be there, I think.
Okay, call for the record. Not numbered, case number not numbered.
Execution petition number,
Execution petition, it is before EAC,
yes,
and then the record would be with Deputy Commissioner.
yes.
Which one need to be called?
Your Honor, DC record,
DC record.
yes.
What other documents will be available before Deputy Commissioner other than your appeal?
That is regarding the RTI applications furnished to the petitioner,
Okay.
wherein I have received my appeal.
Is this the part of challenge?
No, this is not a part of challenge, but
Then-
this is my submission. That's it.
Now, what record is required to be called for? Which
That's it.
one?
That is with regards to the appeal filed on 28/5/2018 by me, which has been furnished to my,
Now, here in this case, you have only challenged the execution,
yes,
order in the execution,
yes, that's it.
not the order. Only you are saying that you have filed appeal.
Yes,
Whether that record, your appeal application, which is available here, required to be called for.
yes, Lordship, it has to be called for you, Lordship.
Okay.
Because if that appeal is pending before the learned Deputy Commissioner's office,
Okay.
then my appeal has to be disposed of first before going
Okay,
through
call
this.
for the record, no? Okay. Then it's noticed. Record from the EAC is also necessary.
Yes, Lordship, EAC with regards to this execution.
Okay,
case.
from the response, from with regards to the appeal. Filed by the petitioner before the Deputy Commissioner, as well as the execution petition before which one? Respondent number? Execution.
Respondent
petition-
number 6, private respondent number 6.
No, execution.
Execution is
Order.
before respondent number 3.
Okay.
Sorry, respondent number
No,
4.
this is
Respondent number
Four, okay. Is ESC?
yes, COC.
No, ESC.
Executive magistrate.
Okay. From the, as well as from the circle officer from executive magistrate council. Lower Siam district, Arunachal Pradesh.
Lordship, also with regards to the record related to the information issued to Metro RTI.
No, that is before the DC only.
Okay.
Having regards to the contention made in the petition and contention made in the petition, it is provided that, it is hereby provided that the person to the order dated 31/10/2023 so they, by this order, it was directed to issue LPC.
Yes, Lordship. Lordship may be still returnable date.
So then not personal, then the operation of the improved order dated 31/10/2023 passed by the executive magistrate Kanku district Lower Siam, Arunachal Pradesh in KNK. Is this a case number?
Yes,
What is the
Lord-
case number of
Lordship, this is-
execution petition?
this is KNK JUD.
KNK stroke JUD within bracket K bracket close
13 of the-
13 stroke 2023 stroke 197 shall remain still. Okay.
Deep Dobraj.
Yes.
May it please your lordship.
Yes.
Lordship, in this instant writ petition, the petitioner has assailed the impugn termination order dated 13/9/2024, whereby petitioner has been terminated from service as a PRT primary teacher without affording opportunity
When?
of hearing. On 13,
Where is the
impugn is at
termination order?
page 38, lordship.
38.
Yes. May I read the process?
Okay. Yes.
Whereas it has been brought to the notice of the competent authority that the following primary teachers have been appointed, recruited without following proper procedure of recruitment rules and posted under the establishment of DDSE. So
Okay,
and
your
so.
name appeared?
Yes, my name is at serial number 6, Your Honor, Your Lordship.
Okay.
And here it has been shown as per this termination that so-called notice has been issued to the petitioner, and then after that it has they have said that the respondent authority has said that replies were also submitted. However, Lordship, this is
That was also considered. Reply
Yeah.
also, okay.
however, no so-called notice was issued to the petitioner, and since there was no so-called notice, there is no question of replying to the so-called notice, Lordship. So this is a blatant lie by the respondent
Yes, who
authority.
appeared for? Police, you are for
I'm
education
for-
department.
Yes, and on behalf
Who
of
issued
TW.
notice? Okay, hard, Mr.
Tata.
Hey, Tata, Learning Council for the petition. I have also heard Mr.
H. Tai.
Learning Council appearing on behalf of the. Your correspondent number?
All respondent number. Your Honor.
Okay. Appearing on behalf of all the respondent 1 to 6.
Your Honor, not all respondent number. 1, 2.
Issue notice. calling upon the respondent to so cause as to why a rule should not be issued is prayed for and all past such orders is to this court may be written properly. Stop. The notice is made returnable within 4 weeks. Stop. Since Mr. So-and-so appeared and accepted notice on behalf of all the respondent number one.
No, not all respondent. 1, 2, 3, 5, and 6.
Okay, 1, 2, 3, 5, and 6. No formal notice will be issued to the said respondents. However, the petitioner shall furnish requisite extra copy to the counsel appearing on behalf of the respondents. Of the respondent staff. The petitioner shall also take steps upon the respondent number 4 by a registered post with ADP, as well as by a usual process within a week from today's start. List is matter after 4 weeks.
Briefly, always.
No one appears. Yes, anyone appears? None appears on call. Okay. None appears on behalf of the petitioner on call. So, Mr. Matukatu, line at DST. Aye. However, Mr. Matukatu, line at DST, aye, is present on behalf of the CBI. And this is what? Writ petition. You are also appearing on behalf of?
We are also reflecting in the court this year also. So we are also appearing for the state level.
Okay, Mr. Active for the state operating staff. In absence of the petition, the matter stand adjourned. List is after 3 days.
Right.
Right.
Your Lordship, this matter may be listed on 3rd.
On 3rd.
3rd of April.
Miss
Sonam Somu.
Land Council for the petitioner praise for listing this matter on 3rd, to which Mr. Ramnath Government has no objection. Let's pray for comment. List this matter on 3rd.
Obliged.
This is the millet yesterday, the day before yesterday's matter. On the instructions to the extent millet some clarifications from the respondent department. Hopefully,
What was this matter about?
That contractual bill, Lordship.
Okay, bill. So
Lordship.
can a direction be given?
My lord, yes, my lord, we'll see, my lord. Yesterday, my lord, there's a issue, my lord. Where, my lord, in my past letter, my lord, that is our letter 9/2/2020. There is, we say, my lord, utilization certificate not applicable, my lord. We say in the letter, my lord, to the respondent number 2, my lord, utilization certificate not applicable. We said, my lord. Now, my lord,
Yes.
now that is also true, my lord. Where, my lord, because, my lord will see, my lord, that letter was dated 9/2/2022, my lord. 9/2/2022, my lord.
22.
And, now I have placed on record, my lord, one record, my lord. My lord will kindly have a look at that, my lord. 9/2, my lord. Well, past page, my lord. Past page, my lord. Now, accordingly, my lord, thereafter, my lord, on the basis of that this is 15 March 2022, my lord.
15 March.
My lord. Respondent number 2 release, my lord, this amount, my lord, 214, my lord. Page number 1, my lord, will see that is dated 15/2/2022, my lord.
Yes.
Serial number 1 in table, my lord.
Yes.
They released 214, my lord. Now, my lord, actually, if he has released some amount where there, we say that utilization certificate not necessary, my lord. Yesterday, my lord asked a question, my lord. That our letter was before the release, my lord.
70.36 lakhs
My lord.
against the foreign claims. What does it mean?
It means, my lord, it means, my lord, 214, 2 crore 14 lakhs was released, my lord, for ITA pass phase, my lord. This is the relevant work, my lord, in
Who released this much of amount?
respondent number 2, my lord.
Respondent number 2 is union.
You no, my lord.
Ministry of Power. Ministry of Power, Lordship, PFC.
Okay.
Now, my lord will see, in term of that, my lord, recovery was made of 118, my lord. They recover 188 lakhs, my lord.
Okay.
Now, thereafter, my lord will see, my lord asks whether we have given them the utilization certificate of rupees 25 lakhs or not, my lord. That, my lord, will find this at page number 2, my lord.
Page 2.
2, my lord.
The serial 2 or page 2?
Page 2, my lord.
Page 2.
Page
Okay, yes.
Just after that, my lord, this is my lord, my lord will see, my lord, to my lord, this is PFC, my lord, India, my lord, in address, my lord, 2 is address, my lord. Finance with attachment, my lord, down below UC of IPS second, my lord, IT, my lord. This is at page number, my lord, this is 3, my lord. This UC, my lord.
UC of IPDS.
IT, my lord. IPDS.
To IT, that 28.3.
The year 23, my lord, 22,
Okay.
my lord.
Okay.
Now, next page, my lord. This is the attachment, my lord.
Okay.
Utilization certificate, my lord.
Form of utilization certificate.
Certified that out of 196 lakhs, my lord. 196 lakhs, my lord.
Okay, that is 196.
As a grant of section state share, my lord, during the year 2012 in the favor of ADPA under this ministry of letter given in margin, my lord. Accordingly, my lord, even we have send them, my lord, this payment receive also, my lord. Now, this part, my lord, they have also accepted, my lord. Now, therefore, my lord, I humbly pray, my lord will kindly note.
This, according to you, is page 3 is a UC.
UC, my lord.
Of this 2 point.
Not 2 point, my lord. Remaining 1.888 they have recovered, my lord.
1.96.
Yes, my lord. 1.96, including state share and the remaining 25 lakhs, my lord, from that 2.14, my lord. Yes, they have recovered 1.88, my lord. First page, my lord, will say they have recovered, my lord, 1.88, my lord. Out of release, payment release of 214, my lord, they have recovered 188, my lord. Responding number 2, my lord.
Okay, so, but then you have submitted UC for 196.
That including the remaining amount in our state share, my lord. Yes, this is 80 into 15, my lord. Oh, 85.
This includes the 188 also.
Not 188, my lord. It include the 214 minus 188, my lord. Remaining amount, my lord.
Remaining is okay. Remaining is 25.
25, my lord.
25 plus
state share goes to 196, my lord.
Okay, where have you? Let us see. Where have you mentioned that it is so and so grant sanction and state share during so and so.
My lord, whatever he is saying, my lord, my friend, he had not incorporated these things in his affidavit. When we have filed that, you have not given the utilization. Now he is coming up with this documents, lordship.
Therefore, my lord,
That is true. That is true. This was not there.
No,
No, my lord, prompted him to submit this letter?
Therefore, my lord will kindly observe the conduct, my lord. Where I am saying so, my lord, conduct of the respondent number 2, my lord.
My affidavit.
Whether they is fair enough to not only us to this honorable court also, my lord. I will indicate those documents, my lord. Now, yes, my lord will know.
So what do you say? Respondent number 2.
Lordship, kindly see my affidavit in page 240. 2024 also we are writing them letter to submit the UC. If, my last affidavit, lordship, kindly see 240. They have not even replied. We have filed this affidavit. They have the.
Then what we'll do is you bring it on record.
Before that, my this I humbly pray, my lord. My lord will kindly note, my lord, whether a respondent number two
No.
is
I'm-
fair
I'm-
enough to
I'm-
ask, and this one before
Yes,
I indicate 2 pages only, my lord.
That is true, but then had you annexed this document?
Yes, my lord,
They would
definitely.
have not said also.
No, my lord.
But then since you did not annex this one, you have.
No, my
not-
lord, no, my lord.
Even after
My
filing
lord,
of the.
categorical statement has also been.
Categorical state we have made, my lord, that reply
that
they
is
have
the
given, my lord.
reflection
Therefore,
of the
Should have
statement.
annexed, should have annexed.
no, my lord, kindly allow me to.
Clear cut, you see, this was,
My-
you see was issued 28/3.
No, my lord, that were, my lord will kindly allow me to indicate 2 pages only, my lord, from their affidavit, my lord. Respondent number 2, my lord, 2 pages.
Anyway, what they are saying, they are disputing that.
No, not disputing, my lord. They have
No, no,
accept, my lord.
Since you did not annex, despite of filing additional affidavit, so you bring it on record, file it in affidavit form.
I will do. Before that, I will, my lord. By before that, my lord, I'll kindly allow me to read 1 page, my lord. They have accepted that they have.
Yes, which one?
Recovery, we have.
Page-
We have.
Page number,
stated-
my lord, page number 160 of their affidavit, my lord. Affidavit, my lord.
My lord, may I pray then, ask them to deposit the amount. Pay me, the issues may be kept open, my lord, for their, my lord, disputes.
Yes, yes.
For their discussion, my lord, for their, my lord, interest,
My
my
friend
lord,
should
I am
not be-
suffered.
They'll recover from respondent number 2.
Yes, respondent number is required to be paid back or required to be, my lord, deposited by him. My lord, but I am praying for it.
He, of course, otherwise would be.
My lord,
ready.
my lord
But
has
then-
already
but then-
seen the conduct of the both the respondents. my lord.
Yes, that is.
Because of them, my lord, I am still there, my lord. Before this honorable court also, my lord, they are contradicting each other, my lord. Just, my lord, my lord, we can imagine how the things are going in the office. But even before this honorable court, they are like, my lord, this is not a trial court, my lord.
My
So
lord-
everything has to be speak on records, my lord.
My lord
Now
will-
the record is very much clear. I have
I-
executed the work.
I
My lord,
appreciate- I
first
appreciate,
deposit,
but-
my lord, my lord, they kindly give a directions to the respondent, both the respondent, to deposit the
Why
amount.
should-
My lord,
why should
whatever the
I-
queries, then
why
maybe,
should-
my lord, they kept open, my lord. That
How can
issues
you
maybe,
claim
my lord, they
against
kept
us?
open, my lord.
How can you claim against us?
Okay.
You cannot claim against us.
My lord will kindly have a look at page number 160, my lord. For a open, my lord.
160 or?
160 of their affidavit in opposition, my lord. That is 160, page number, this, now serial, my lord, in sequence, my lord. 160, page number 16, my lord. 160, my lord, 160.
Yes.
160, my lord, 160.
Yesterday, this we could not actually, it was difficult to understand.
In my
because
lord.
Prior to the notification.
Yes, Minister.
It was not
Indeed,
paginated.
indeed.
Yesterday, I called the registry and registry said, okay, the earlier affidavit was filed prior to the notification.
Yes,
And the pagination is, whatever the pagination they have done is only after.
After,
notification.
yes, Minister.
And that some of the affidavit was not paginated.
Yes, ma'am.
And it cannot be paginated also.
Yes, ma'am.
Because it was prior to the notification.
Yes, ma'am.
Okay, yes.
160, ma'am.
160, yes.
Now, my lord had hard, my lord. The counsel for the respondent repeatedly say, my lord, we have not filed given them the UC of the 25, my lord. 160 down below table, my lord. Table below, my lord. It's serial number 2, my lord. IT page 2, 8.3, UC submitted, my lord, 1.96, my lord.
Yeah, then.
On their record itself, they are saying, yes, we have submitted this, my lord.
Columns, Lordship, then next.
1.96, my lord. On
Next
their record itself, they are saying submitted. But then technically, my lord, they are not. I am saying, my lord, they are not fair. Not fair to this honorable court also, my lord. This is the matter of record, my lord. The learned counsel for the respondent is submitting otherwise, my lord. UC submitted 1.96, my lord. I have placed on
I
record,
think you will have to direct the respondent.
my lord.
No,
Additionally, my lord,
Better you file,
my lord.
the direction will go to respondent also.
Right.
But because under the circumstances, yesterday he did not point out.
Yes, my lord. As
He did
But
not
that
point
is-
out this also.
Well,
And
subject to-
it appears that UC submitted, and they are still submitting that UC was.
Yes, my lord. Yes, I was on the day itself. I was given the affidavit, my lord. That's why I cannot point out, my lord.
Okay.
Not entire amount UC has been submitted, Lordship. There in page number 160, Lordship. Balance to be submitted, Lordship. This is clear.
Yes, balance. We have not received the amount. How we submit the UC?
This is because
How
one.
can you- Then why don't you?
Yes, my
why
lord.
don't-
And then you see, they have released 2.14.
2 point. And they expected they have recovered 1.88, my lord.
Remaining amount also probably you may have to submit UC for the remaining amount.
Yes.
also.
Remaining amount, my lord, without they being released the fund, my lord. How we can submit the UC, my lord? That is an issue,
You
my
have
lord.
just admitted that
My-
2.14 crore.
My lord.
Been released by them.
Yes.
Your UC is showing only for 196.
6, my lord.
That is inclusive of your state.
East
share.
share, my lord.
So that is why the rest of the amount you probably have to submit UC for the rest of the amount.
Raise of there's no raise of
Plus minus, my lord, and my lord, may kindly fix this matter on third, my lord.
Third.
Or third.
no, my third, my lord.
Madam, then
Yes,
in that case,
we need to we need to file affidavit, my lord.
my lord,
Then
affidavit is not, my lord, may I pray that matter may be listed on third.
My lord,
In the meantime.
kindly,
In the meantime, they will file
Third
affidavit.
April, my lord.
yes, my lord is directing us to place this on record, my lord. I need
Affidavit is
my
not
lord,
required,
one more,
to my
one more
knowledge.
prayer, lordship. My lord,
That
one more
has been
prayer.
reflected in the affidavit itself. That is the, my lord, the clarification, my lord. Otherwise, it is stated in the affidavit, my lord.
This copy, then for his knowledge, the respondent number 2 may be also forwarded.
Yeah, my
My lord, that is the only communications made between the parties. That
That
has
is-
been
that-
categorically
that is right.
stated in the affidavit,
Because
my lord.
They are still claiming, that is why.
On third, my lord.
Okay.
third, my lord.
Also had Mr. El Parme, Land Council appearing on behalf of.
Lordship, my friend will also
Our
reply to
department.
my April 24 letter also, Lordship.
No, my lord.
My lord, page number
My lord,
240.
therefore, my lord, in that case, my lord, if they need longer date, my lord, may I pray that, my lord, direction may be,
Mr. Parme, you are for 1, 3, and 4.
My
Yes,
lord.
Okay, Land Council appearing on.
ask them to, my lord, deposit the amount, my lord.
On behalf of 1, 3, and 4. And Mr.
S. Roy, my lord.
S. Roy,
Respondent number 2.
Land Council appearing on behalf of the respondent number 2 staff. Let's wait for. This is matter again on
Third, my lord. April 1.
3rd April. 3rd April.
Lordship.
Okay.
Deep level.
So according to you, the affidavit is not required.
My lord, we will bring this in record, my lord.
Okay,
Throw affidavit, that will be
Not required.
better, my lord.
Mr. Okay, the respondent, Mr. El Parme, Land Council for respondent number 1, 3, and 4 is at liberty to file affidavit. If additional affidavit in order to bring on record the document, including the UC
Yeah.
submitted by the respondent government.
My lord.
Okay.
Deep
The
level.
respondent, this was submitted by UC submitted by state respondent.
Yes, yes, yes.
Okay.
Highly obvious.
And also respond to my affidavit, Lordship. Otherwise,
Yes,
Lordship, Lordship.
Your Honor, this matter may be adjourned and fixed on 24 of April. Your Honor.
Hmm?
This matter may be adjourned for today and fixed on 24 of April.
24
Of
of
April.
April.
Yes, Your Honor.
You are for
I'm for the petitioner on behalf of A. Sharma.
L.
A. Sharma.
Okay, Mr.
H. Tai.
H. H.
Tai.
Tai.
Yes, Your Honor.
Appearing on behalf of Mr. L. Sankam. Praise for adjournment of the matter for the day. And to be fixed on
24.
24 April 2025. So he has also obtained obtained consent of the Land Council for the respondent. According to the prayer is allowed, list this matter on 24 April. Okay.
15 also, 16 also same, Your Honor.
16?
Also same.
Same.
Yes, Your Honor.
Similar order. Here also for respondent.
I'm for the petitioner.
For the petitioner.
Yes,
Okay,
sir.
Okay. Here also you have obtained consent from the other side.
Yes, Your Honor.
Okay. Same date. Okay.
My pleasure.
Yes.
Your Lordship, on last occasion, Your Lordship had asked about the arrest of the petitioner. Since this matter was arised from the SIC case, so he was never arrested in this matter. Now state have to file the affidavit. If your lordship may see order dated 12/03/2025.
You have received the subsistence allowance?
That we haven't received any information.
No information from
No.
your client?
Yes.
You were asked to obtain instruction and then whether you were arrested?
No, he was
Not
arrested.
arrested?
Not.
Okay, then you obtain instruction from him that whether he has received any subsistence allowance.
Yes, your lordship.
Okay.
Yes.
By an order dated 12/3/2025, the Learned Counsel for the petitioner was directed to inform this court as to whether the petitioner has received subsistence allowance, received the subsistence allowance or not. In this regard, Miss
Etsomo.
Learned Counsel for the petition, appearing on behalf of the petitioner, submits that as he has no knowledge about, okay, she could not contact the client. He has no knowledge about whether the petitioner had received subsistence allowance or not. We have to pray for some more time to obtain instruction in this regard. They are allowed to stop. With regards to the query by this court as to whether the petitioner was arrested at any point of time or not, Ms. Somo, Learned Counsel for the petitioner, submits that. With regard to the second question, as to whether Ms. Somo, Learned Counsel for the petitioner, submits that the petitioner was never been arrested in connection with the, never been arrested at any point of time. Please pray for further 2 weeks time is given to Learned Counsel for the petitioner to obtain necessary instruction is directed on 28, directed on 12/3/2025. Stop. Mr. Learned Counsel for the, you are correspondent?
Yes, Your Honor, on behalf of Titagum.
Okay. Appearing on behalf of Mr.
Titagum,
Please,
Standing Counsel for
Learned
Education
Standing
Department.
Counsel for the
Education Department.
Education Department is also present. Okay.
Most of it.
Yeah, 17, okay. Please have to take 2 weeks. Yeah? Yeah. Yes.
That lordship, according to submission of the respondent counsel lordship, last date lordship, I have to submit the application to the deputy commissioner lordship. For interim hearing lordship.
Yes, Mr. Law, Land Standing Counsel. So, what is your submission?
Since he has submitted,
You were to obtain necessary instruction, whether you have any instruction.
it is not going to submit this repetition.
They have submitted representation.
Let the DC consider it. Depends on him now.
They are insisting for the interim.
With short time, you will decide. With short time, you will decide.
Today maybe allow interim lordship, my humble prayer lordship.
When this representation was submitted,
Office of the Deputy Commissioner lordship.
whether this was received,
Yes, lordship.
what the respondent says, the DC. Any response to this representation?
No, lordship.
Who are these applicants?
The applicant is lordship, Sonam Samu lordship.
No, this applicant, whether this applicant is the petitioner?
Yes, lordship, petitioner lordship.
How many petitioners are there?
There are lordship, five petitioner lordship. Five petitioner. Petitioner.
All of them are owner of the land or what?
Owner of the lane is also the lordship.
There is only one.
There is only one.
Yes,
But
lordship.
who are these petitioners?
So, some are lordship as a shopkeeper and that's all.
Which one is the land owner?
The land owner is lordship. There have a annexure lordship. Rita Jamo.
Rita Jamo
Rita Jamo is a lordship trading license owner.
is a petitioner.
Yes, lordship.
Where?
That Rita Jamo is lordship actually is give to power of attorney to lordship.
To whom?
To lordship Deepak Yangfo lordship. Deepak Yangfo lordship.
Petitioner number?
Deepak Yangfo is petitioner number. Lordship.
Where is power of attorney?
It's a page number lordship.
Whether by order issued by the deputy commissioner while allowing whether this power of attorney on the basis of the power of attorney can the market be open? That becomes difficult, I think. It's not the owner whom the condition was imposed, but then some other person who has violated, and because of that, again the people suffer. And you say that we are suffering, whereas you do not know the order, the condition imposed in the order while for giving permission. heard Mr.
Honi Tanatara,
Learned Counsel for the petition. I have also heard Mr. N. Loan, Learned Senior Government Advocate for the state respondent number. One and two.
One.
Okay. For both the state respondent number 1 and 2. Okay. By filing this writ petition under Article, the application under Article 226 of the Constitution of India, the petitioner has challenged the order dated 5/3/2025 issued by the deputy, issued by the respondent number 2, the Deputy Commissioner Capital Itanagar, within bracket respondent number 2, by which issued by the respondent, okay, by which, while exercising the power under section 162 of PNS 2023, prohibited the operation of Tuesday market at Chimpu, Itanagar, with immediate effect till further order. The case of the petitioner is that by an order dated 29/4/2016, so this Rita Jamo is not a petitioner.
Rita Jamo is not petitioner. He is only authorized for the license lordship.
Srimati Rita Jamo
Is annexed 6 lordship, page number 22 lordship.
Page number?
Page number 22 lordship. Power of
What is that?
Page number 22 lordship in petition copy.
Was granted for Google Daily Markets at Chimpu, Itanagar, at Chimpu village, Itanagar, with certain terms and conditions. Including the condition that the traffic should not be disturbed at any cost. Sufficient space for vehicle parking should be maintained. Sufficient volunteers should be employed for traffic regulation during peak hours. with the further condition that violation of which shall invite legal action. That in the among others with the following terms and conditions. Huh? Okay. The further case of the petition is that the petitioners are in the power of attorney holder and attorney holder who established the Tuesday market when it was established.
It was established 20 April 2021 also.
It was first established on 20 April.
At the date, the lordship, it was established also after the power of attorney also.
After the power of attorney. When it was executed, 21.
Yes.
Okay. And establish the Tuesday market as per in accordance with the terms and conditions imposed upon by the district magistrate while granting permission. Start, huh? However, however, by an interim order dated 5/3/2025 from the respondent number 2, Deputy Commissioner, Capital Itanagar, has prohibited the operation of the Tuesday market at Chinku, Itanagar on the ground that it was operated unauthorizedly and the petitioner has not maintained the distance of 20 meters from the center of NH dash 415 on both sides. The amounts are on the ground. Okay. By an order dated on 13/3/2023, a notice was issued on the interim prayer to be heard on returnable date on 2025. Start on 2025, on the prayer of the Dhaneshwari Government Advocate. Time was granted granted to him in order to obtain necessary instruction on the interim prayer. Again on 25/3/2025, the Dhaneshwari Government Advocate was granted further time Senior Government Advocate Samir, despite of communication for seeking instruction, he had no any instruction is forthcoming. Since the notice was already accepted, the respondents will file affidavit within 2 weeks from today. In the upon hearing the parties and on consideration, it is provided that in consideration the operation of the impugn order number DC ICC JUD Tuesday market 01/2025 dated 5/3/2025 shall remain suspended till the next returnable date on the following terms and conditions. Column 1. The traffic should not be disturbed at any cost. 2. Sufficient space for vehicle parking should be maintained. 3. Sufficient volunteers should be employed for traffic regulation during peak hours. 4. Liquor or any kind of gambling shall strictly be prohibited. Okay. Following terms and conditions is enumerated in the order dated 29/4/2016. Number 1. Para. It is further made clear that on violation of any of the above terms and condition and the terms and condition imposed upon the respondent on 29 respondent in order dated 29 April 2016 from the respondent is respondent deputy commissioner. Respondent number 2 is at liberty to initiate any legal action. In accordance with the law. Okay, this is my offer. 2 weeks.
Lordship, I am for the petitioner.
Yes.
Service not completed, your lordship, as per your business.
Okay. Mr.
Techi Ita.
Hmm?
Techi Ita.
Techi?
Ita. Notice was issued on 3rd March 2025, and it was directed to take steps, and we have taken steps upon respondent number 2. Lordship.
And it's awaited.
Okay. Respect of respondent number
2.
2.
Private respondent number 2.
It is still awaited.
Yes.
Then not complete.
Service not completed, your lordship.
Okay.
Yes, your lord.
CD may be called for your
Okay.
lordship.
Mr. and Techi. What Techi?
Techi Ita. Ita.
Techi Ita.
Yes, ITA.
Your name is there?
Yes. No. In cause this, my name is not here. Of course, I have
You are appearing on behalf of?
petitioner.
When your name is not
here in
reflected
cause
or not filed as Wakalatnama, you should always mention the name of the person for whom you are appearing.
Yes,
Okay?
in Rama.
Because
We have
otherwise
done.
the other side will always object. Okay, appearing on behalf of, and appears on, appearing on, or hard Mr. So-and-so Techi, who appearing on behalf of Mr. N. Ramalani, counsel to the petitioner. Staff. Also have Mr. Okay, Lana addition of PT staff. The office note dated 27/3/25 reflect that the notice upon the respondent and number 2 is still awaited. In view of the above, please stationary after 2 weeks.
Yeah,
After 3 weeks.
3 weeks, your
After
lordship.
3 weeks.
Three weeks.
Obliged.
Obliged.
Yes.
Appellation.
Yes.
Well, before coming to the facts of the case, this is the same matter which came up yesterday. And this court has called a scan lower court record, trial court record was called for. So first of all, it's lead to a certain.
What is this?
Otherwise, this is the case of the under section 528 of the BNS jointly filed by the petitioner, two petitioner, which is complainant and the accused person. In connection with the.
Just a minute. Joint petition.
Yes. And purely based on the matrimonial issues between the.
Okay, you have received the scan copy?
Lordship, we call for the scan copy of the TCR. So, Lordship, in the record, Lordship, I think it has not reached yet, Lordship.
Okay, so what do we do?
Lordship, we can again call for we can wait for some time, Lordship.
So.
It's not yet.
Yes,
It is
my lord.
available. Could have disposed of, but unless the record is available.
Yes, my lord. So since the record was called for, so in this instance, I will not press the court to pass the order today. However, Your Honor, my lord will find that the trial is going to be commenced by 4 April 2025, by coming April. Therefore, we may be protected by granting the interim till that the further proceeding in connection with the Itanagar Women PS case number.
Charge sheet already filed here.
Yes, charge sheet has already filed. Therefore, we are here praying before the lordship to quashing of the FIR along with the charge sheet. This is the case of
Charge sheet already filed before the court of
the Chief Judicial Magistrate.
Judicial Magistrate, which court? UPI?
UPI, here only. My lord, may kindly see the page number 29. This is the annexure D, where my lord, the summon to accuse has been received from the Chief Judicial Magistrate.
Okay. Hi, Mr. Modi, Line Council for the petition. Also have this Lagan petition PP for the state of AP stuff. The record, the scanned copy of the trial court record, which is still awaited. In view of the law, this is matter after 2 weeks. Okay, stop. Huh? So have you mentioned the GR case?
My lord, GR case I have mentioned, and my lord in page.
Whether have you received any summon?
Yes, my lord. That I am saying, my lord, in annexure D, my lord, page number 29.
Page
29, my lord.
29.
Yes. So the trial is going to be commenced by 4 of February 2024, 25. Therefore, my lord, I am praying for interim till, my lord, this GR case number 4441 of 21, my lord, to be stayed, my lord, during the pendency of this criminal petition. Just only on this view that seeing the imminent trial to be started, so the matter has been come up again to the matter.
The Line Council for the petition assignment is that the matter arising out of the matrimonial dispute. However, the dispute between the petitioner, the accused petitioner number, accused petitioner number
1
and informant
as
petitioner
petition
number
number 2.
have been amicably settled by executing. Where is the
In page number 26, my lord, deed of mutual agreement, the matter has been compromised between the parties.
deed of mutual settlement?
On 26th day of March 2025.
The Line Council for the petition further submits that the first FIR filed against the accused petitioner number 1 has already been set aside and quashed by this court.
On
by
16,
an order dated 16/11/2022, passed in
criminal petition number,
criminal petition number 112/2012.
2022.
And the present case arising out of the subsequent second FIR lodged by the informant petitioner number 2 against the accused petitioner number 1. See? And since the matter has amicably been settled between the parties, there is a possibility of this case decided in his favor. Possibility that this case will be decided in his favor. However, the chief judicial magistrate has, however, the case has already been submitted into charge sheet. The chief judicial magistrate has registered the case being, what is the case number?
GR number 4,
GR
444
number 444/2021 and issue summons
to the petition number
to the
1.
accused petitioner number 1 for his appearance on 4/4/2025. Therefore, he insists for the interim prayer, in view of the above. In view of the submission made in the submission of the Learned Counsel for the petition. Then upon hearing the counsel for the parties, it is provided that the further proceeding of the GR case number 4/4/2021 arising out of
Itanagar PS case number.
Itanagar PS case, Itanagar WPS case number 65/2021 under section 498A/506 IPC pending before the court of the Chief Judicial Magistrate shall remain suspended till the next Itanagar date. Okay, this is matter after 2 weeks.
Lordship, in the meantime, scan copy of this, maybe I can call for.
It's awaited only.
Yes, Lordship.
So we continue.
A reminder may be sent, Lordship.
Okay. Then in the above, scan copy is awaited there. Issue reminder for the scan copy of the GR case number 4.
Obliged, Lordship.
One word correction, my lord, in place of the 2022, this should have been 2022, my lord.
What?
GR case number 1112 of 2022. That was,
1112.
yes.
1112. The earlier case.
Yes, earlier case.
Earlier case, correct, it's
2022.
See the record also, huh? Don't make mistake. Okay. Yeah.
All right.
Right.
Yes, Mr. Moore. What is this matter about?
This is a civil revision petition.
Okay, revision. Okay, Mr. Ingo. Learned Counsel for the applicant. This is an application filed under section 5 of the Limitation Act 1963, read with section 151 of Civil Procedure Code 1908 for condonation of delay of
16 days.
Frame for condonation of delay of 16 days in filing the connected civil revision petition. Issue notice returnable by 4 rules. The petitioner shall take steps upon the respondent by a registered post with AD.
Lordship, 3 weeks.
By the usual process.
And thus the lordship.
Dusty also?
Yes, Lordship.
Are they private?
Yes, Lordship. They are private respondent.
Within, okay, a week from today, stop, huh? Age period for comma, Dusty service is also allowed. However, the petitioner shall file, and Dusty service is also allowed. Within
2 weeks, Lordship.
within two, okay. Then, usual process, huh? Age period for comma, Dusty service is also allowed. The step be taken within. No, that postal will be within 1 week.
Within 1 week.
Earlier one, okay? Then justice as press for comma justice service is also allowed to be routed through the registry.
Yes.
Okay. And to be routed through registry and file. To be routed through registry within 2 weeks. from
Within 2
today,
weeks, Lordship.
and to file affidavit to that effect. So, okay. List is matter after 4 weeks.
After 3 weeks, Lordship.
After 3 weeks.
Yes.
Okay.
Deeply obliged.
Yes. Oh. You know, the appeal is filed by Dulal Borua.
Yes.
Bora.
Yes.
You are for.
I'm
Dulal Bora.
Amicus one.
Amicus.
Yes.
And Nino Ratan is for. His name is also there. He is for.
Who they play?
This case might file before he was appointed as additional
Okay.
AG.
Okay, yes, it was 2022.
Yes.
Yes. Are you ready?
Yes.
But petition, appellant is not there. He's,
Amicus.
yeah, actually, your lordships,
What is the punishment? Yes, sir. And Amicus is open. It's present in absence of any representation from on behalf of the applicant. This matter is taken in June. This matter after 2 weeks. Okay.
obliged.
Yes.
Yes, my lord. Please, my lord. I am for the petitioner, my lord. My lord, during the pendency of the present petition, the accused was arrested by.
Have we received scanned copy of the case diary?
Yes. Now it is charge sheeted.
May I?
Yes, case.
It is charge sheeted.
Yes, charge sheeted only.
Case diary or it's,
No, case. Up.
if it is
We-
charge sheeted, then it
We have sought for updated case diary, but in their reply, in IO's reply, it was in apprised before this court that matter is already charge sheeted.
charge sheeted.
Yes, on 21st of
We
February.
should have called for the case record then. Case has already been charge sheeted. It is before the court.
Okay, my lord. My lordship, may I submit something?
Oh, we wanted to dispose this matter. Actually,
Yes, my lord. There is sufficient ground. May I submit, my lord, please?
Yes, sir.
Not just for the convenience of this court, if I may kindly. Lords, am I audible?
Yes.
I appear on behalf of the complainant, which is the
Yes.
respondent number 2. So, my lords, the matter has been settled.
Who is that?
My lords, respondent number 2,
Oh, you're alone.
the complainant. What's the matter?
This
Settled
was suddenly
and
changed. You are correspondent number 2. You have any objection?
no, my lords, we don't have any objection. It may be
File
called.
affidavit. Have you filed affidavit?
No, my lords, we haven't filed affidavit.
Okay.
My
Just a
lord
minute.
directs
Then
me.
in that case, probably the petitioner has also to amend incorporating the GR case number, because now the case has already been charged
Exactly,
sheeted.
exactly.
So you have to incorporate and add the
My
GR
lordship,
case
my
also.
lordship,
So,
my lordship, may I submit something? May I submit?
What-
Please
what-
allow me. to
yes,
submit. Kindly, kindly
You are
see my
for?
affidavit filed.
you
Petitioner,
are for petitioner.
petitioner.
Now,
Yes,
now
my
the case has already been charge sheeted. The status
my
status
lordship.
of the case has changed. Now you have to write or incorporate the name of the case before pending before the Chief Judicial Magistrate. It has been registered as a GR case. You incorporate that also. Since there is no problem, he has no objection. That will be considered, but then you amend the petition, incorporating
my
the
lord.
GR number, because the case has already been charge sheeted. Status of the case has changed. Okay.
Okay, my lord.
Hard.
So, my lordship, now the honorable court might disposing in my petition.
Hard, Mr. You are Dahiya.
I'm Virender Singh, an associate of the Mr. Dahiya.
Okay. What is R?
Virender Singh. My lordship, may I something? May I
R.
submit
Virender
something?
Singh, Land Council for a petitioner. I've also heard. Mr. Okay, G. Taro, Land Addition PP. No. And Mr. You are Mr. the respondent.
Aditya Agarwal, my lords.
Anit.
Aditya, ADITYA, my lords. Aditya Agarwal. Agarwal.
Land Council for the respondent number 2. Mr. G. Taro, Land Additional Government Additional EP submits that the case has already been submitted in the charge sheet. In view of the above, the PP, in view of the above, also the scanned copy of the case record.
Yes.
Problem. Since the case has already been charged sheeted, the petitioner shall also file additional affidavit.
30th January.
By
30th
incorporating
January.
the case number registered before the Chief Judicial Magistrate.
Yes.
Okay. On such, okay, file additional affidavit. Okay, age grade 4 by Telangana Council for a party. 30th of. When do you want?
My lordship.
When do you want?
Lords, any short date is fine with me.
When can you? Then you need to file affidavit. You see, incorporating, collect the number, GR number from the court, Chief Judicial Magistrate Court, and then file small 1-page affidavit saying that, giving the number, because that number, the GR number is to be set aside and quashed, isn't it? Okay. So lease is after 2 weeks.
Oblige.
Lords, may kindly fix a date. Sorry, Lords, just may kindly fix a date